All right, good afternoon, everybody. I appreciate you accommodating us with a little bit of a schedule kind of running behind. We'll go ahead and convene. This is the Leverett Subcommittee of Judiciary Non-Civil. And so if you're here for another subcommittee meeting, you may want to change planes. And we'll go ahead and recognize Representative Fleming to have a word of prayer to get started.
Please bow your heads with me. Lord, as we always do, we pause now as we begin this meeting. We ask for your wisdom to be in this room with us, particularly as we close toward busy days in this legislature. Help us to be able to follow and understand, and most of all, have the wisdom to make decisions which are best for the people of this great state. These things we ask in our Lord's name. Amen.
Thank you, Representative. We've got a couple of bills on the agenda today. We'll try to get started. First, deferring to the chairman on the agenda here, I'll ask Chairman Stan Gunner to present his bill. That's House Bill 450.
Okay. Thank you, Mr. Chairman. All right, ladies and gentlemen, House Bill 450, I really need an amendment to it or a sub on it. I had originally talked to Legislative Council about setting the Criminal Data Exchange Board from the clerks to the AOC, and it really should be to the Judicial Council. So that's a change that I need to make in this. But that's the only change that I'm aware of that needs to be made. There may be others. In particular, if there's a code section that deals exclusively with the AOC, it may need to change it over to a code section that deals with the Judicial Council. The Criminal Data Exchange is putting standards together right now, and this bill will not hinder their work. It won't slow that down. But by putting it with the Judicial Council, I believe that it will make it much more effective. The Judicial Council deals already in data collection in other fields, and the CDX will also be part of that or is affected by the data that is collected elsewhere. So in my mind, I think that the Judicial Council is the better organization to put the CDX under. And so that's why I dropped this bill. All right, this also has appropriations to it, and I want to talk about that a minute. The Clerk's Authority has gotten $1.5 million in the FY23 budget, $350 of which has been appropriated. Another $101.15 million is requested for the fiscal year 24 budget. The problem there is that the board itself rejected that request, but it was made anyway. So I think that kind of shows a little bit of a disconnect in the organization, and that's basically what I'm here is. I think it's better with the Judicial Council. I think the data and the everything that the board needs is better served over with the Judicial Council. I'm not saying that the clerks can't collect it or do the job to get the information to the Criminal Data Exchange. I just think that there's more information that they don't have access to or control that's with the Judicial Council, which is, I think, the reason why this needs to be over there. And so I'll take any questions. Hopefully I can answer them.
Thank you, Mr. Chairman. Just for the sake of, say, subcommittee chairmen who don't do a lot of criminal work, what exactly is the Criminal Case Data Exchange Board, and what does it do?
Well, that's a good question. I wish I knew everything that it did, but I'm told that this one of the things that I dealt with over the years, and this board has come on just recently, and part of what it's doing is to collect information, especially for the GCIC reports, the criminal history of a person. And when I was a DA and judge, those reports were getting worse and more difficult to read and understand what was being charged. And to me, this is a simple, we've got enough technology out there now that this should be simple and should be in a way that you can read these things so that you know that it was just an arrest, or that the warrant was dismissed, or if the case was actually taken forward. I've seen GCIC reports where I couldn't even tell if the charge that was against the individual ever proceeded to court, or whatever happened to it. So it's difficult to read, and that's just one example. I think CDX may affect other areas of the law and the data that the courts work on. Again, which is why I want to see it with the Judicial Council. I think it's better there.
Is the CDX, or the Criminal Case Data Exchange Board, is it a relatively new creation, or was it moved from some other place to the clerk?
I think it's relatively new, and unfortunately, or fortunately, however you want to look at it, last year I supported Senate Bill 441, which put it with the clerks. And in hindsight, in looking at that, that probably was a mistake.
Okay. All right, you've got a few questions here. I'll shut up and let some other members of the committee ask questions. Representative Fleming?
Thank you, Mr. Chairman. Chairman Leverett, just first of all, for our posture that we're in, so I'll try to form my questions accordingly. I know that Chairman Gunter said he had a sub he needed to bring to us and some changes. I didn't know, is the chair's intention for us to vote on this today, or are we going to wait on that sub, or do you know?
Well, I think that partly depends on Chairman Gunter. He had discussed possibly having some amendments, but we'll
in looking at it since we talked, we probably do want to just discuss it today and then bring a sub on it.
Okay. Thank you. I'll tailor my questions accordingly.
Thank you for clarifying.
Mr. Chairman, thank you. Chairman Gunter, thank you. So the two questions, if I may. The first one is about the money, and the second one is about what we're doing here. Mm-hmm. I tried to follow with you when you were talking about appropriations, but I apologize. I didn't fully understand what you were telling us.
Well, it's the board rejected
and when you say the board, that's part of what I'm trying to...
CDX board. CDX Advisory Board rejected the idea of making a request for the money that was given to or that's been requested in the FY24 budget.
The governor put it in his budget and they don't want it.
No. I think the executive director asked for it, even though they had voted. Now, this is my understanding, and I may be wrong, and he can clear that up when he gets up here. But the board had rejected the idea of asking for that money, and it was still made. The request was still made.
Thank you. So as best I can tell, what we're doing here, we're collecting information about the court system here, right?
Yes.
And we passed a bill last year to begin that process.
Yes.
And this is going to make a change in that process.
No.
No.
Not in the process.
Okay.
The board can still collect the data that it needs to do its job.
Correct.
It's just going to be with an organization that has even more data that could work with the data that they're collecting for the criminal cases.
So maybe to try to understand that, my question would be, what data are we collecting, and who has it better than the clerks?
I don't have answers to that.
Okay.
I wish I'd had more time to work on this bill.
Okay.
But that's...
I'll hold right there,
Yeah.
Mr. Chairman.
And maybe some of these other witnesses can explain that to
Yes,
you.
sir. Yes, sir. Thank you.
Give you a better picture.
All right. Thank you, Representative Fleming. Representative Reeves? Representative Gullett? 13.
Thank you, Chairman. You said you're not familiar if this has been something before besides what we did last year. Is that
I
right?
don't think there was a Criminal Data Exchange Advisory Board.
There was something in 2018. I don't know exactly what it was, but I think it was under Georgia Technology Association. And I came about this just in a crazy way a while ago, and it just triggered a brain, a little hair stick up. And I don't know much more about that, but I do think something in the past was there. I don't know if it was less members or more members or exactly what they're trying to do, but it's related. So
I think the job that they're trying to do right now is to set standards for you tech guys to be able to go forward on it.
okay, thank you.
Thank you. Representative Silcox?
Yes. Thank you, Mr. Chairman. So my question, Chairman Gunner, would be, so you think this will help overall in the collection of all this criminal data, so we can get accurate reports to all the judges, so they can know what is going on with all of these cases.
Right, help in the collection and the organization of the data, yes.
Great, thank you.
Thank you. Any other questions for Chairman Gunner? All right, pursuant to your request, we'll just do this as a hearing only, but I think we do have a witness, Jill Travis. Thank you, Chairman Gunner.
Thank you.
Good morning. Is it afternoon now?
Good afternoon.
Members of the committee, thank you for hearing from me. I have already spoken with Chairman Gunter with regard to the ask that we have is to be included, the criminal defense lawyers to be included in the board membership. I think it's around line 70. You have executive directors of various agencies. And while criminal defense lawyers are not inputting the data into the system, they are using what's created from it. And we'd very much like to be included in the process, because I think that sometimes I come to you and I say, I wish you would have included us earlier in the conversation. So I think that we could bring some wisdom, and I think the chairman was amenable to adding executive director of the Georgia Association of Criminal Defense Lawyers or something along those lines. Thank you.
Thank you. Any questions of Ms. Travis? I think she was pretty succinct and clear in her ask, so we appreciate that. All right.
Thank you.
Hold on, Chairman Gunner, I think has a question.
Let me just, you had spoken to me about this. And
I did.
I have no objection just to let the committee know about this kind of change.
Thank you.
Thank you. I don't think you have any other questions. All right, Mike Holloman, I think you wanted to speak too.
Yes, sir.
Come on up.
I'll
Pick-
try and make up for her brevity.
Pick a microphone, any microphone.
Thank you. Each of you should have a manila folder that has a number of different documents, and I'm going to go through them from front to back very quickly, or as quickly as can be done. The Criminal Data Exchange Board that currently exists has been noted was a creature of Senate Bill 441. It did exist prior to that. It was originally part of Governor Deal's criminal justice reform. It was originally staffed by GCIC, Georgia Crime Information Center, technology provider operating under Georgia Technology Authority. That group chose to attack the problem of criminal dispositions not being accepted into the CCH. That's the criminal case history. That's what everybody just calls the background system. Dispositions were not getting into that. It's because, and actually there's a document in here and we'll cover why that's happening in Georgia and 25 other states. So the tack that previous group took was not a bad objective. There was a program called CJEP, C-J-E-P. CJEP is a process that we used to call JDX, Judicial Data Exchange, back in 2008. By the way, clerks have been wrestling with this problem since 2007, July 1st of 2007 to be exact. It's been on our radar every day, every year since that time, because the burden of this charge mapping that we'll discuss has fallen solely on the clerks, regardless if the data that's in error or missing came from the jailer, the prosecutor, or anyone else. Our dispositions, valid court dispositions, are not being accepted into the CCH system because of some other absence of data or reconciliation. We don't have the ability. Sometimes we don't even know who didn't do something. So it's been almost an insurmountable problem now for 15 years. So along comes, well, I'm going to finish the background on that. I wasn't really intending. The previous board, they were doing a project, but it became very expensive. They went through $8 million in 3 years and managed to get 2 counties connected through this API. That's an application program interface. And it allows a case management system at the local level to communicate directly with the CCH system and to receive error messages immediately. Mr. Greg Allen, Clerk of Superior Court for Forsyth County, was one of the 2 counties where that was successfully implemented. But after 3 years and relatively little progress and a lot of money being spent, Governor Kemp came into office and OPB looked at this project and not fully understanding it, which is understandable. This is really complicated. They chose to just pull the plug on the project. I think it's a valid project, but it's not what we're proposing. And there's no proposal, to my knowledge, or appropriation request to start CGIP up again. When we interviewed Mike Curtis, who was the Georgia Technology Authority project manager for that effort, the first thing he said to us when we spoke to him right after the session ended was, I don't know what you folks are going to propose, but if you're going to propose restarting CGIP, don't even start unless they'll guarantee you $25 million and understand that it will take you 3 to 5 years to finish the implementation of CGIP. Well, it wasn't our intention to do that, even though I think it's a worthy project. I just knew that was a non-starter. You know, I come to you, I'm asking for an additional 1.1 million and everybody's throwing their hands up like, oh, 25 million would be a non-starter. So anyway, that's the history. The document in front of you, the first page, is just simply, we weren't totally sure of the reasoning behind this bill because, quite frankly, the CDX board has been very active. We've held, as you can see here, 5 publicly noticed board meetings. We adopted administrative procedures, elected a chair. Mr. Pete Skandalakis, the Prosecuting Attorney's Counsel, is the chair of the CDX board. We've had all 5 of the meetings have had attendees from 30 to 40 or more people, usually about 15 in person and another 20 or 30 via Zoom. We've had tremendous participation, including from the 5 voting members that are part of the Judicial Council. They have 5 of 19 of the voting members of the current board. So they've had a voice, and I have not heard any dissatisfaction from any of the 19 members about the progress and the work that we've done. So what have we done? Well, one of the things you heard about standards, one of the principal focus of Senate Bill 441 was the belief that there needed to be a standards document that brought together all of the different requirements of every law enforcement, prosecutors, the court, to report data. We adopted those standards, and they are theoretically the force of law right now because the statute requires all of the parties, once the standards have been adopted, which they have, to follow those standards. So you can look at the next document, and I'm only going to summarize this in 2. It's called Disposition Reporting. This is a National Center for State Courts document. I don't expect you to read it now, but if you really want to dive in, summarize this whole document. Charge mapping is hard. And even in states like Massachusetts with 14 counties and a unified judiciary, they have trouble charge mapping. So what does charge mapping mean? That means at every step from the jailer inputting the charges as a person is booked into jail throughout the entire life of that offender's case, it requires each of those charges to be reconciled or amended as it flows through. And if that doesn't happen, or if there's missing data or an incorrect charge code, it gets kicked back at the end, even though the disposition that the clerks report on behalf of a judge who's has adjudicated a case and found it, even if that is 100% accurate, it is rejected from the system. That's the problem. So, disposition reporting a challenge, that just simply says we're not the only ones that have had problem with this. It's every state, and about half the states try to do charge mapping versus the other half who do something called case matching, which is much simpler. That's what we used to call the bucket system. You just take it and put it in here and everything's accepted. I should mention that GCIC, the report will tell you there may be good reasons to do charge mapping, but you got to accept the reality that it is an impediment to getting the final disposition recorded into the background system. So this little 7.5.1, that is one piece out of the standards that were adopted by the board back at the turn of the year. This will fix the problem of dispositions without this hub that we're proposing, and I'll talk about the appropriation request in a moment. If this is accepted and followed by everybody, including GCIC, what, as you can see, acceptance of court dispositions, the board has adopted this standard as being required. GCIC shall accept submitted dispositions of court case charges which report a judge's actual disposition of a court charge. GCIC/CCH will not reject dispositions on the basis of data in conflict with or missing from CCH, such as CTN values, charge codes, or arrest data. CTN is count, like count 1, count 2, count 3. If that's followed, but GCI is not going to like this because they want their case charge mapping to work. And we're okay with that. This standard doesn't prohibit them from continuing to attempt to do charge mapping. Just don't make us do it. In fact, in a recent meeting, they said, well, if you pass this, we're going to have to do this, and we don't always know. And we said, join the club. We've been trying to do this for 15 years. We know you don't know because we don't know. But right now, the entire burden is on the clerk, and when the newspaper reports or certain legislators put very onerous bills targeted solely at us for the disposition problem, we're going, hey, that's a foul. We can't pick up the phone and call the jailer. I mean, can you imagine in Fulton County, the clerk, and by the way, Miss Tina Robinson, Fulton County clerk, they do an enormous number of cases, as you can imagine. They got 12 or 14 judges cranking them out every day of the week. She's going to pick up the call. I'm sorry, 20? Okay. And that's just Superior. So she's going to call Sheriff Labatt and get somebody on the jail hotline and say, hey, you need to fix this date in the original thing, or you need to do this or that. That's not going to happen. Jason Bragg, Effingham County, he can't do it in that size of county. Sheila Studdard, Fayette County. They can't. And Sheila is a former law enforcement officer and has made it her sole mission in life since this happened to make sure Fayette County did the best they could do because she knows the importance to law enforcement. This document, most common errors, I won't go through them, but let me tell you there are 22, and this report was created by GCIC and given to us as part of our research. Of these 22, I would say 3 or 4 of these common rejection areas are due to an error on the part of the court, i.e. the Superior Court clerk. That's all that's there for. The next document looks like this. It says sample transaction summary of OBITS data. And I really should have organized, it looks like this, y'all. I really should have organized this in reverse. If you'll flip to the last page, which is page 5, you'll see something that says notification of OBTS data file processing. That's one data file that comes back from GCIC when there's been an error. And as you can see, it's in XML format and it's not human readable. In order for this to work, each submitter's case management system has to be able to read this XML and then import it into their case management system. Some can do that, and it's not an insurmountable problem. I'm just telling you that's not the case right now. If you start on page 2, which is the back of that first page, you'll see what begins basically a 3-page report. That is that same XML port put in English. And you'll see that it's spread over, as I said, at least 2.5 pages. Also, something about this that I can't even see, this data is not organized around the OTN. That's the offender tracking number. That's the person that the case is named after. It's not even organized correctly, although this is what clerks have to use right now. 2.5 pages of spread out, uncoordinated data. If you'll look on page 1, this is what we are doing right now with the funding that we got last year, the $350,000 that we got. We have put online with real world data that is updated every day at 8 p.m. This is only court data, and we can turn that report that you see that takes 2.5 pages into this simple half a page report that organizes things by OTN so that the clerk doesn't have to search through this nearly 3-page document to find all of the information that they need. We're doing this now with our meager resources. The next page is a 2-pager called CDX Hub Executive Summary. Let me speak to one thing that Chairman Gunter said. It is true that the CDX board did not want to move ahead this year with a funding request for the hub. That does not mean that they rejected the hub, and you'll have to talk to each of those members of the board. In fact, the idea of a hub is supported by everyone on the board with the exception of GCIC. And the reason GCIC has given to not support it is, number one, I think they believe that what we are proposing with this hub is a alternate background system, and that is not the case. There are all sorts of federal requirements and obligations that we surely don't want to get into. Also, if you were to really build out a system, it wouldn't be a $1.5 million ask, it would be a $15 million ask. What the hub that we're proposing, quite simply, and I urge you to read this 2-pager, that will really give you an idea about what it is exactly that we're proposing to do, is very simply an analytic tool that all of the members of the CDX board can use online to research the progress of a case from the jail report through the final disposition, and it will help us or GCIC or whoever is trying to reconcile. It'll help us to see what's happened and, more importantly, what's not happened. When an obits that's a fingerprint file. Once the fingerprint goes up into the system, there's now a charge there. When you don't see any activity on that charge after a year, it'll ring a bell. We'll have a trigger, and we'll say, hey, there's an obits form that is now 12 months, or you can set the amount 6 months, 12 months. This hub would tell people when something hasn't happened, and it would communicate across all of these agencies what everyone else has done or hasn't done. In other words, that example I said, for Ms. Robinson to have to call the Fulton Sheriff and ask a question, she wouldn't have to do that were the hub in existence. You could simply query the hub and see that. We can generate reports on the back of that page, reports that we could have available within the next 6 to 12 months. Our unfixed OTNs, again, that's an offender tracking number, a transaction summary, a transmission history, and a CCH rejection category. And it would look something like that earlier half-page report that I showed you that we are already doing with the limited data that we have. You can see also, if we had additional data from GCIC, you could do a CDX agency report card. Right now, the only report publicly available is on the GCIC website, and it's a pie chart, and it shows one number for all of Fulton County. Y'all, there's 15 municipalities, 4 or 5 layers of courts, all reporting into GCIC. There's I'm trying to think of the designation that there are over 1,000 submitters into the ORI. Thank you, Sheila. There are 1,000 ORIs, which signifies an entity that has the ability to put data, or the obligation, I should say, to put data into the GCIC system. This report is just a pie chart that says this many made it, this many went into suspension, this many were rejected. It doesn't begin to point to where the problem is. Our hub could track by ORI, so you could see exactly who is not doing what they're supposed to do. I will tell you, we're talking about pardons and paroles, all kinds of people who I will tell you probably don't even know what they're supposed to be doing. I don't think it's willful. It's also the fact that if you have 1,000 ORIs, how many thousand people is that? What's the turnover in an ADA in the DA's office with ADAs? We all know it. I mean, Mr. Scandalakis, I've heard him communicate to y'all all the time. They need more money to retain ADAs. Every level, from jailer to ADA to the courts, has tremendous turnover. That's why when people say, well, we need to be a big education campaign, that'll solve it. Well, it'll solve it maybe for this year. Next year, you've got 20 to 30% turnover up through the system. The standards will help with a sustained, and I mean every year for eternity. You've got to train people. That's part of the $200,000 additional that we put in our core budget, not proposed for the hub. We're saying somebody's got to, on behalf of the CDX board, communicate these standards, and I'm going as fast. Finally, this document, it is an in-depth description of what the hub proposes to do. I'm not going to get into it. The summary is about all. And then, just in case it comes up, it is the opinion of GCIC that the hub is not viable because neither the CDX board nor the Council of Superior Court Clerks is a criminal justice agency. Well, first of all, this is from this last page is from federal regs. 20.3 definition, criminal justice agency means courts. Well, I think surely in the context that we're talking about, the courts would include the Superior Court Clerk. After all, where is all of the data that we're talking about in the courts? It's not in the judges' chambers. It's not there. It's not at the AOC. It's not at the Judicial Council. It's in the Clerk of Court's office. It is not at the AOC. It's not at the Judicial Council. So number one, I would take exception that a criminal justice agency, the definition of courts, doesn't include us. But if it doesn't, look at 20.33, dissemination of criminal history record information. First of all, it repeats on item 1 to criminal justice agencies. But look down at number 6, to non-criminal justice governmental agencies performing criminal justice dispatching functions or data processing information services for criminal justice agency. What are we talking about? That's what the hub literally, that is a perfect definition of what the hub that we propose is. So whether it's a criminal justice agency or non-criminal justice agency, I'm telling you, I think it's a valid. Now, why did we choose to go forward? Because time is of the essence, and our opinion was that we're going to put it on the table, and if the legislature declines to fund, so be it. No harm, no foul. You've got $1 million you can play with to put somewhere else. But we believe it is a justified and legitimate solution that will help GCIC accomplish their charge matching and get dispositions into the system.
Thank you. Thank you, Mike. Any questions for this witness? Ripton Fleming?
Thank you, Mr. Chairman. Sometimes I try to figure out what we're doing, and usually I'm wrong. And I'm trying to figure out what we're after here. And I think I have an idea, but I'm going to let you correct me. In Georgia, we have a criminal justice data issue of being able to record everything that happens correctly and making sure the people put into the system right information and that's stored somewhere. Is that the summary of what we're trying to fix here?
That's a summary of it, yes, sir.
Okay. So a few years back, we had an issue on the civil side of matters and we decided that we would choose between two options. That is allowing the government, us, the state, to try to come up with an electronic filing system for civil records, or we would turn to the private sector who is already successfully doing it in part. After a lot of debate, we finally turned to the private sector. The company that I'm familiar with is called Peach Court.
Yep.
Although some people said that it wouldn't be done right, I don't know that we've had a bill down here since I can remember in 6 years having to fix that problem, which usually means when we don't hear about it, we get it right to start with. I was always of the mind, although I don't understand the issue, that if we create a government agency to try to solve the criminal data problem, we would create another bureaucracy that unfortunately was trying to tackle a problem which they may not be best able to handle. And here's the question I'd say to you. If this is what I think it is, why don't we turn back to the private sector who already understands how to do this on the civil side and say, can you come up with a solution for us on the criminal side and quit creating government agencies to try to figure this out? Maybe I'm out there in left field.
No.
Help me
Representative Fleming, as with the civil system, which we designed, the Superior Court clerks put out the functional requirements. I'm sure Mr. Gull over there knows what a functional requirements document is. It's a detailed layout of exactly what you want something to do. We then handed it over to an outside contractor, as Representative Fleming has pointed out, and they took our roadmap and built software around it. We're not proposing, we're proposing something similar with the hub. Now, we have engaged with a software development company that built our jury management software that we've had in operation since 2012. They're doing some preliminary work around a website that lets clerks look at current data and produce those reports that I showed you earlier in my presentation. But that's entirely within the realm of possibility how we might approach that. I can guarantee you we're not proposing to build another agency. This hub would be under the auspices of the CDX board. It could be assessed by any member of the CDX board with the concurrence of the board. And that includes, by the way, the Judicial Council. It would be a perfect tool for them to receive the data that they want. And that brings up a point. Chairman Gunter mentioned this wealth of data that is existing in Judicial Council. I'm not aware of any. Now, they have recently publicized and put out about a week or two ago a project that is, I guess I'll call it NODS, N-O-D-S, for lack of it doesn't have a real project name. NODS is National Online Data Standards. It's another artifact of NCSC. And what NODS does, it attempts to lay out a standard file map for all manner of criminal data. The idea being that regardless of what your case management calls something, you map your data element in your case management system to the NODS equivalent. And so that way, when you export data, it translates your core data into NODS. This project was just unveiled recently. There has not been one piece of data that has been transferred to this project. I understand that the AOC got a grant that they intend to build a portal through which this data can be collected, but that hadn't happened. And also, the spreadsheet, the NOD spreadsheet has like 12 tabs, 17 tabs, and anywhere from 4 data elements to 20 or 30 data on each tab. We have examined every one of those tabs in that NODS document. And while, again, we generally think NODS is not a bad thing, but to attempt to collect this tremendous wide range, a significant number of which is not even being put into any system. A lot of it are scanned paper documents that go into a system somewhere. Nobody's taking that scanned document and entering these data elements. And they require all manner of agencies. Now, that's not to say it's not a valid project. The AOC and the Judicial Council will tell you that they are bombarded with requests for data analytics about what's going on in the courts, and they are. And so, valid. But if there's no data now, and that system is probably a 3 to 5 year project if everything goes well before it's functional. Now that's just a fact. So I would tell you they don't have this data. And not only that, the correlation between the NODS data elements and what the CDX people are dealing with, which is an OTN with obits, charge data, warrants, that is only a minimal part of this larger effort.
Just so I said, if I may, Mr. Chairman, just so I understand one money issue that you mentioned. I remember after we created this civil filing system based upon private companies coming in and figuring out how to do it for us, there was a big debate occurred about, okay, now we turn to the problem of criminal filing and all the records that go along with it. And instead of turning to the private sector to solve this problem, we decided to put millions of dollars into a government agency to try to figure it out. Is that the 8 to 10 million you said we spent, and we ended up having 2 counties with systems?
Yes, sir.
Okay. Thank you, Mr. Chairman.
Thank you, Representative Fleming. Chairman Gunner.
Thank you. As to Barry's question, back when I was district attorney, we did the tracker program, and the way we did that was we hired 2 guys that were software writers. We educated them as to what the system, how it worked, and they wrote the program, and I believe within a year we were using it. It has expanded now into a lot of the metro counties. Every circuit now has it, and contains much of the data that they need for this criminal data exchange. So, and the other thing that Mr. Holloman said was that back in, I think this was some organization, some form of this organization was in place all the way back to 2007. And that's been my frustration with this. Whether it's this organization or what, it's been 16 years since I was promised that we would have a GCIC report we could read. And that's the issue for me in this. There's been no progress. We did a tracker program within a year. I just can't see why it's taking so long to get everything done. And that's my ignorance, I'm sure, on all the issues involved. But, I mean, the idea of going to private enterprise might be a good idea. I don't have a problem with that. But I can also say to you, I think we can do it ourselves with the right organization. That's my comment.
Thank you, Chairman Gunner. Representative Neal.
Yes, thank you to the chair. Just a quick clarification question. So when it comes to this particular database, when you mentioned that this database helps carve out or identify what's missing, are you referencing, so as far as the partnerships you mentioned, public and private, someone will partner with someone in the private sector to outline the full life cycle from arrest to sentencing to make sure that everything's accounted for. So when everything's input, it is outlining what's missing in that process. Is that correct?
Yes, ma'am. I do want to take the opportunity to clarify. The problem started in 2007, and about halfway through that larger hub report, you'll see a color bar graph that shows very vividly the exact time, because successful dispositions went from here to 0 in 2007. There was no CDX board until 2018 that attempted to approach the problem through the CGIP effort that I mentioned, that was the $8 million 3-year. Prior to that, GCIC, it was their system that they put in, and by the way, Jay Harrell, who is one of their tracker developers, will tell you that Phil Koborowski, who is our guy that created the initial hub in 2001, where criminal data was originally mandated to be transmitted electronically. We've got the guy who wrote the original ability to get that through. Both Phil and Jay will tell you that GCIC was alerted that the proposal to turn that system on without working things through was going to result in exactly what happened. Everything crashed. And it hasn't. There's not been any progress. But I'll say, whose burden was that? Well, from 2007 till 2018, it was solely GCIC. I mean, it's their system. I can find emails where we had meetings in 2008 with various committees, alarming, telling the General Assembly, things are broke. This thing's gone off the rails. But yet, nothing happened. We have our opportunity. I think we've made more progress in 7 months than in the last 15 years. And I believe our hub, as proposed, which is supported by a number of members, but Mr. Skandalakis and others didn't think it was timely to put a budget request in. I said, I'm going to stick my neck out and put it out there. If the legislature doesn't like it, you've got the money to put somewhere else.
Thank you. Any follow-up, Representative? All right. Any further questions of this witness? I don't see any.
Thank you very much.
Thank you. All right. Do we have any other witnesses to talk to this bill, to speak to the bill? All right. Well, Chairman Gunner, given your suggestion, perhaps we'll just do this as a hearing only, and then if you have a substitute and wish to bring that back, we'll certainly try to consider it this week. Thank you. All right. Next, I think we'll go to Representative Gullett's House Bill 231. And we have a few witnesses who want to speak to that. You want to? I know you've already presented. Do you wish to make any just sort of opening statement or remarks before we get to the witnesses?
13. No, I think in the interest of time, I'll just do a closing remark maybe.
That'll be great. All right, so as for House Bill 231, I have DA Tasha Mosley.
Just gotta pass these out real quick.
Okay, sure. We're going to pass out some materials too. Here, why don't we just hand them down? You can give us just 1 second.
Oh, no problem, sir.
Madam DA. Try to get those around to the members.
Yes. Yeah, it's the one from last week.
All right, I think they can handle both inputs at one time. So why don't you go ahead and
Thank you, Mr.
just if you'll
Chairman.
introduce yourselves for us and then give us your testimony.
I'm Tasha Mosley. I'm the District Attorney of the Clayton Judicial Circuit. I am also President of the District Attorneys Association. And what am I? The Chair of the PAC Executive Board. I carry too many titles to remember all of this. So I am here, I don't like coming down to the Gold Dome. I'm most comfortable in my courtroom. So forgive me if I start preaching, because I am the daughter of a Baptist minister. But I'm here in opposition to speak for the majority that is in opposition of 231. This bill would basically cover 74 DAs and Solicitor Generals. There are 24 full-time Solicitor Generals, 50 district attorneys. Now, I sat back the last meeting and I just listened because I wanted to hear the arguments and where everybody was coming from. And it basically seemed that the committee was a little upset with 2 DAs and maybe 1 Solicitor General. And so we're talking about 4.05% that we're talking about building a committee, I'm going to say a JQC, but the DA oversight bill for approximately 4.05% of us, because we are unhappy with things that they have said or they have done. Now, we talked about it, looked at the bill, and was talking about misfeasance and malfeasance. And most people just make this assumption about DAs, that all we do is prosecute criminal cases. That's just the majority of what I do, what we're required to do. But you guys have written stuff in the statutes that, have partly made me a clerk. I have to put stuff in to the GCIC when I change stuff. I am responsible. I am the chair of the Child Fatality Review Board. And when I say I mean all DAs, all 50 of us. Child Fatality Review Board. We also are responsible for if the municipalities or the cities or the counties want a bond. We also have to do that. That was a trip trying to learn all of that, what in the world I was supposed to do and not do. So it brings me to this point. When you put misfeasance and malfeasance in there, you're now telling me that if I fail to, let's just go with the GCIC, the gentleman with the GCIC. Somebody can sit there and say, well, Ms. Mosley, your judicial circuit did not do this, did not put that in. Somebody can bring me before this board that you're trying to put together and say, misfeasance, you didn't intentionally do it, but you failed to do it. Even though I'm trying to put murderers and rapists and others in jail. Let's go to the Child Fatality Review Board. It's mandatory. We have to do mandatory reporting. I know some of my colleagues that are on the minority letter, that have signed that minority letter, who haven't complied with the CFR. Because we sit there and we look at the stats. So that's misfeasance, or it could possibly be malfeasance. Are we going to bring them before that board when they fail to do that? Because they might just be overwhelmed with what they're supposed to do. Bonds. I remember I had a double ear infection laid out on my couch when one of my cities was sitting there saying, well, we need this paperwork signed. I couldn't drive because my balance was off. They bought the paperwork to my house. I'm laying on my stomach trying to read a 600-page document before I sign it. If I had failed to sign it on that particular day and so that they could file it, the bond rate would have gone up. The interest rate. Is that misfeasance or malfeasance? By your writing, I could be bought before that board because their bond rate, their interest rate might have gone up. There are those little things that you don't think about for 74 people that you're talking about bringing a committee before a committee on these minor things. We have a lot on our plate. Now let's talk about these cases. Now you made a big deal about some of what my colleagues wrote. Not everything. After the session, me and Representative Gullett had a conversation. I wasn't happy about a whole lot of stuff. You know, a lot of stuff that y'all do don't make me happy. But I haven't asked for a committee. You know, we just vote you out. And that's the option that these people, the citizens, have. I talked to a senator the other night because we were talking about marijuana. I don't think y'all understand what happened when you passed the hemp bill. I was an SG, and I'm also the DA. I was elected in 2008, took office in 2009 as the SG of Clayton County, and Governor Kemp appointed me in 2019 to take over as DA, and I was elected in 2020. But before I left the SG's office, possession of marijuana, less than an ounce, could not prosecute it. Know why? The GBI said, we're no longer going to test marijuana less than an ounce. You're overwhelming us. When you passed the hemp bill, guess what they didn't have a test for? The difference between marijuana and hemp. So you put the onus back on local governments who don't have the money. There's no testing available to distinguish between hemp and marijuana. So those cases sat. We didn't prosecute them. They said at no point in time, because my oath says that I can't bring an accusation or an indictment against somebody until I know that I can prove it. Well, guess what I couldn't prove? What's marijuana. Let's go to DUIs, because I remember Representative Peachtree talking about DUIs. Well, I don't know if you keep up with the law. The Supreme Court has basically kicked our behinds when it comes to DUI. They have basically said the Georgia Constitution gives you more rights, your Fifth Amendment rights against self-incrimination. So taking a deep breath is not natural. And so you can't ask somebody to take a deep breath and blow into an intoxilizer 5,000. That's against their constitutional right against self-incrimination. Now let's go down to, Metro Atlanta. We've got a bunch of hospitals. We have a bunch of urgent cares. My sheriff's department has, well, I don't know what they've got right now, but we did have a nurse. You know, once we get a new sheriff, we might actually know what's going on down there. But they had a medical facility where my police department and my municipalities could take a DUI suspect into the jail and have a phlebotomist withdraw the blood. And I could use that once, and this is after a search warrant, to use that in a DUI. But what if you're in a small county, rural county, that there's no medical facility, no hospital, and the closest one is an hour away? Now, do you really think that your sheriff's department or your PD, well, it's usually sheriffs, are going to drive, first of all, get their magistrate court judge up to write that search warrant, to get the blood drawn, and then drive an hour there and then an hour back, knowing that the possibility of the person's BAC is going down as that drive is taking place? And you now pull that person off the road at a time when police departments and sheriff's departments are having a hard time staffing. We're losing those cases left and right on technicalities, which is not of our doing. If you look at a case and you see that it's not a blood draw and there was happened to be a breath test, you know it's gone out. Or if they didn't do the breath test and all they did was the walk and turn, basically what the courts are telling us, you know what, making somebody do a walk and turn to one leg stand is also against their Fifth Amendment rights, against self-incrimination. So what do? What do we do when the Supreme Court is tying our hands? What do we do when that family sits there and says, Miss Mosley, why didn't you bring a DUI charge, vehicular homicide first degree, because we smelled the alcohol? The officer said their eyes were bloodshot and glassy. What do we do when I sit there and tell the family, I have no evidence? There is nothing. They can now write a complaint. And I could be coming before a board and sitting there explaining myself, wasting my time and my money, or either my county's money or either your money. Because does Attorney General Carr represent us in those instances? Do you pay me back? Because trust and believes every day is a complaint. I was on the news the other day not because I didn't want to prosecute a case, but because the case was continued. Because the public defender's office has changed attorneys over and over. And I've got 22 victims of rape that want their day in court. I keep getting angry emails because I am trying to the best of my ability, review officer-involved shootings where people died. I'm getting nice, nasty emails. Those people could complain on me, and I'm still waiting for GBI to give me what I need to review to see if anything is going on. It goes on and on and on and on. You want us to do our jobs, but there's a lack of funding. You don't give me the money. Let's break it down. Starting salary for an ADA is $55,000. Somewhere in there, right, Pete? 55 and maybe some change. Was it 55 or 56 starting salary for an ADA? 55 for somebody coming out of law school, it's got student loans, and is just trying to live here in Metro Atlanta. They're going to the insurance agencies. So that means the ones that I do get, that if I'm fortunate enough to hold on to, don't stay that long. They go. I have 4 spots open right now. Doesn't have anything to do with my management skills, but it has everything to do, the lack of money. You know, other jurisdictions are calling my guys my best of the best and sitting there saying, how much is Tasha paying you? I'll give you 30 to 40 grand more. They go. I told one of them, I said, shoot, I want to go with you for that type money. But I still have to do my job and cover that courtroom and move people around, even though I'm 4 short, to make sure that my murders and rapists. But think about somebody that's on the back burner when I sit there and say, well, I've got to move this prosecutor to another courtroom to cover something else. They could file a complaint against me. And now I'm answering because I've moved people because of my management, because I put people where I need to put them to make sure that I'm doing my job and I'm unnecessarily answering these questions. You talked about, oh, I'm sorry. I'm hurried up. Okay, I promise in 3 minutes I'll get this done because my watch is telling me to stand up. Due process. You've got a judge right now, Court of Appeals, has been up, 2-3 years? No due process? You think this is going to be quick. It's not going to be quick. We have our due process. I promise you, we're lawyers. We know how to drag it out. We know how to drag it out 2 to 3 years. Okay? So it's not going to be something that's quick. You have the ability with the articles of impeachment right now to move it a lot quicker. In the instances of the ones that we talked about last week, you can do this committee. It'll be formed by 2024, which is an election year for those individuals. By the time to go through the process, it's going to be 2026. By that time, their communities might have already voted them out. So in summary, the minority group that signed, please understand there's over 10 million people in the state of Georgia. Those 21, and I can't even say 21, go break it down to 20, because one of the 21 is now a judge, represents 27% of the community, of the population of the state of Georgia. 73% of us represent, the majority of us represent 73% of the population, a little over 8 million. They want us in office. Let them vote us out. Let them tell us when we're doing a bad job, because all we're doing is following the criminal justice reform that started years ago when Governor Nathan Deal said, keep them out of jail. Because the jail, it was costing us too much money. Now we can go back to the old way, but are you prepared to pay the money for people going to jail? That's it. Thank you.
Thank you, D.A. Mosley. Does well, I think you do have some questions. Is that Representative Chairman Sains?
Thank you. Thank you, District Attorney Mosley. Appreciate your testimony. And I mean this sincerely. Do you consider yourself to be a good district attorney and meet the obligations of your office?
I am the best that I can be. Some days I do not feel like I'm meeting the obligations because there's just not enough time or money in the day to do everything I need to do.
I appreciate that, and your knowledge is evident. With that being said, do you believe you mentioned something about the voters having the oversight to district attorneys, and like us, we're elected officers. I don't have the ability to introduce a bill that's unconstitutional. Would you agree?
Correct.
In the same respect, I think the parallel that we're looking for in this legislature is that we don't, though the voters get to decide who their district attorney is, that the district attorney doesn't get to decide to not meet their constitutional obligations, and that's where we're trying to utilize our legislative oversight in ensuring that whether it be 4.05% of the population or 30% of the population, that every Georgian has a public safety infrastructure that they can depend on. Do you propose another method to do that versus the appointment structure that we're putting in for a council that we're representing?
No, because I think you can handle it. I think you keep comparing us to the judges real quick. Remember, we are all attorneys, whereas you've got a small population of judges that are not attorneys, so therefore the bar cannot handle them, cannot hold them liable, when they violate a rule, whereas all of us, all DAs and all SGs are members of the bar. And so you've got the bar. So you actually have already the two-headed beast, y'all, and the state bar that can take care of when we screw up, because none of us are perfect. But when we screw up, you have that two-headed beast that can take care of it. I don't think you need a three-headed beast where you're going to add, even though I read the bill and it said that you're not going to pay the committee members, the investigative panel or whatever, you still got to have an executive director, an investigator, a staff there. You're talking about forming a committee, I'm not a numbers person, probably about $1 million a year, when you already have two ways of handling it. Why build the bureaucracy, add more, and have taxpayers paying more money?
Small follow-up. Are you aware of either of those two methods being utilized to remove a district attorney?
And before she could be removed, the voters voted her out.
So neither of those two methods have resulted in the removal of a district attorney.
Yes. It is how you look at it. I can't remember the judicial circuit, but it's out east. The process began, but the voters voted her out, and she's still in the process right now, and they're looking at disbarring. So I don't know exactly how much longer, exactly how much further, but yes, that person, because of their wrongdoings, the voters got to them before the bar, but the bar is still going forward with the process to disbar that person.
Thank you.
You're welcome.
Thank you, Chairman Saines. Representative Fleming.
Thank you, Mr. Chairman. Thank you for coming today.
No problem.
Appreciate you informing us on some of the things that we passed that we didn't know what we were doing. I want to ask you about. I want to ask you about another
We
one.
get that a lot.
I want to ask you about another one of those.
Yes, sir.
We passed something down here a few years ago called the Judicial Qualifications Commission.
Right.
It's an oversight panel, somewhat similar to this prosecutorial oversight panel for judges.
Correct.
One of your fellow prosecutors last week came and testified against that and said we should do away with the Judicial Qualifications Commission also. Do you advocate that we should do away with that oversight?
No, because I use
you're
that.
different than the judges. Please explain to me how.
Let me tell you how we're different. Because
Okay.
you've got a small, as I stated earlier, you have a population of judges that are not members of the state bar. So there's no oversight of them, period. So without the JQC, you would have nobody overseeing what they do or not do. Whereas we have you, and we've got the state bar because it is required by law that all solicitor generals and all DAs are members in good standing of the state bar of Georgia. Not so for the different levels of judges. There's a small population. It's not required to be a member of the bar.
Are there any judges that the Judicial Qualifications Commission has ever had to remove or asked to resign that you think they did a bad job with?
I don't know all of the cases. I know that there's some that have probably done some things that they should not have done that they left.
You think that would work similarly with the Prosecutorial Oversight Commission, that maybe when they begin their investigations against prosecutors who have done some things
Right.
they shouldn't have done, they'll go ahead and leave?
No, we're lawyers. We like to fight. That's what we do.
I think most of those Superior Court judges were lawyers too. But let me move on to a second line
Not
of
all of
questioning
them.
here, if I may.
Yeah.
You talked about other DA offices coming in, and it sounds like poaching some of your members, some of your lawyers, and offering them more money.
Right.
How can another district attorney's office offer more money when they receive the same state funding from us?
You got counties. Remember, we are dual.
They successfully negotiated with their county commissions to get more money, to pay more money to their DAs. Have you done that?
You know which judicial circuit I'm from? Clayton. Right now, we're bogged down in lawsuits, sir. You know, from my sheriff, I would love to go ask them for money. Every time I do ask them for money, they look at me, smile, and laugh, and say, "Put it in the budget." I put it in the budget. They cross it out the budget. It is right now. I am battling a beast that I don't control. That I've got. I think I'm a tier 1, level 1 county, but I am Metro Atlanta. Bills were written federally and locally where I cannot use the tax money from the gas and other stuff that my county was receiving $35+ million a year. So that put us in the hole too. So once again, I kind of get messed up all the way around because of where I'm situated, because I don't get any benefit from Hartsfield-Jackson International Airport, but yet and still I am tasked with prosecuting every case that comes out of that.
Well,
So
let me ask it this way then. You've explained to us very eloquently how all the problems you suffer from have nothing to do with you but belong to everybody else. Is there anything that you're not doing as a district attorney that maybe you could do that would make it better?
yeah, basically not prosecute a whole bunch of people that are just annoying and have not caused us any danger. I have to put my money in and use it best in those areas where there is a danger that those individuals need to be in jail. Those little guys that are breaking into cars or whatever, you know what, you kind of, right now with the backlog that I have and my prosecutors carrying a caseload of 400 to 500 cases, yeah, I'm putting my resources where they belong, and that's on the murderers, the rapists, the burglars, the ag assaults, the ones that we are afraid of, not the ones that tick us off.
Last question, Mr. Chairman. Some of your fellow prosecutors who we're concerned about have come up with lists of crimes that they are not going to prosecute, things that we, the legislature, pass, the governor signs, are the law of the land, but they choose not to prosecute them.
Right.
Have you yourself also come up with a list of crimes that you're not going to prosecute?
Nope.
Have you done anything about the people who have done that?
I've talked to them.
And?
And I believe that some of them we've changed their minds. Listen, if you haven't noticed, I'm probably one of the most outspoken of the DAs. And I will put it this way, unlike some of my fellow DAs who tell everything, understand my conversations were private, and I made it very clear of where I stand, and that their stance has caused me problems. I don't like being down here. I shouldn't have to be sitting here arguing over this for something I have not done. I am a career prosecutor. I've been a prosecutor for 25 years.
Last question, Mr. Chairman, if I may. I think you just hit the nail on the head. You just got through telling us you don't want to go public with some of the problems of your fellow prosecutors and talk about them here. Isn't that really what we're trying to get out here, so that some oversight of your fellow DAs, besides us depending on you to correct the problem?
I think everybody, the way it's been publicized, I think everybody knows of everybody's problems. The way I took your question was if I went to them one-on-one, because I'm a woman and I will go to another woman and express my problems with that person without, now have we spoke about it publicly? Yes, in our committee meetings. I mean, with the association, we've all sat there and verbalized our problems with those individuals. But I've also, as a woman, gone to those women and said, these are the issues that I'm having. This is what you have caused. Do you see what you have done? And that's where those conversations, I mean, that's all I can do.
But no action on y'all's part at this time.
What action can we take other than?
Exactly. That's all the questions I have, Mr. Chairman.
No problem.
Thank you, Representative Fleming. I believe Representative Reeves was next.
Couple of quick questions, Mr. Chairman, if I may. Thanks for your leadership in the DA's group. I know y'all do the best you can with what you've got to work with.
Thank
and have
you,
a
sir.
tough job, and definitely would have gone to your dad's church after listening to you. And I definitely am going to behave in Clayton County, because sounds like you're a great prosecutor. One of the representatives brought up the nonpartisan DA's bill in the last hearing.
Right.
And I went and signed that bill after hearing about that good idea. Has your organization weighed in on that concept of going nonpartisan on
Yes,
this?
sir. Yes, sir. And we have decided not to support that bill.
Okay.
We want to stay partisan, sir.
I think I would encourage y'all to reconsider it, look around the country, look at the judges that are nonpartisan. In my area in Gwinnett County, the magistrate court and probate court went nonpartisan within the last decade or so. And I think every voter in the county getting to have a say on offices that are legal in nature, I think, has a good effect. It has confidence in the judiciary, and it sort of keeps those offices in the middle of the road. And I think a lot of these aggravation issues that are happening out of the primary rather than the general election. So I would encourage your organization to take a closer look at that. I think that would help the landscape. That DUI issue you mentioned about that Supreme Court decision about DUIs, have y'all weighed in on that issue?
We have weighed in, and I think we're doing our best, but
Okay.
that's going to take a constitutional amendment probably.
There's legislation either pending or that's going to get filed this week if it wasn't last week on that issue. So I would encourage y'all to weigh in on that, because we need to tighten that up.
Yeah.
Drunk driving is something we can't have with all this traffic around, and
Correct.
it scares me to know that the law went the wrong direction on that recently, so I hope we get that fixed. The issue of impeachment, we had a history lesson last time, and
Right.
you know, I don't know if it's comforting or discomforting to know we got some volunteers and some nominations on that as a plan B on this, but you know, judges can be impeached in Georgia also.
Right.
And there's still a JQC. I think it's preferable to have, you know, a professional body rather than having an impeachment trial under the Gold Dome. So, you know, I think the JQC is a preferable model to having impeachment trials. But you know, from my experience, my dad retired from the DA's office in Americus a few years ago, and just in my lifetime, you had one DA who met an untimely death while in office.
Right.
For various reasons, and then you had another one who had a death penalty level case that sort of overwhelmed that DA, and there was a backlog, and the retired DA in Macon had to come in at state expense and clear out a backlog based on problems there. And I think if there were a body of professionals from the ranks of the DAs and prosecutors who could intervene in situations and take care of it rather than having issues pile up over years or 4 years waiting to an election, I think that'd be preferable to the status quo, and that is no criticism of any individual DA, just experience over the years and looking at comparing the JQC to some problems that have arisen with prosecutors. Nothing personal to anybody now, but just over time, seeing the contrast of judge problems getting cleaned up versus DA problems lingering on for years or terms. People suffer. Public corruption is something that, you know, could happen if a DA is not fully engaged, as well as crime. And then backlogs that take years and state resources. You know, the $1 million figure was mentioned. If you have hundreds of cases pile up, it's going to cost $1 million worth of, you know, ADA or retired DA prosecuting attorneys counsel time to come in and take care of a crisis. So just some thoughts from my perspective. And I note the Senate, I think, passed this on last week. And, you know, it's an issue that people are carefully considering, but that JQC model is just really persuasive. That seems to have worked.
Yeah, I hear what you're saying. And right now, what we're coming out of the pandemic, none of us have ever been there before. And I'm telling you, it is hard with that backlog, because I know for me, my judicial circuit, when we shut down in March of 2020, I think it wasn't until May of 2021 that I was able to have grand jury. So for well over a year. So I had to run 4 concurrent grand juries in one term to get that backlog clogged up, you know, pulled out. And then I basically caused another backlog because we had one jury trial a week with the judges rotating. And just imagine the murders and everything else were still occurring. So I'm still trying to get out of that backlog. So it's hard. It's going to be a while before any of us. As far as your partisan is concerned, I heard what you said as far as that, but every voter does have a right, or it does have a right to vote, and it's called the general. If there's a Republican and there's a Democrat, they have that right. But at the same time, there was one group of people that you didn't put in there that also deal with the law, and that's law enforcement, that's sheriffs. So if we're talking about all of us following the law, then nobody should be partisan if that's the case. I prefer letting the local government make that determination, the local citizens, because the citizens can make that determination if they want their sheriff, they want their DA and SG to be partisan or nonpartisan. I think that's something left to the local level rather than having a state government entity, because it has been done locally. So let the citizens of that judicial circuit make the determination if they want their SG to be partisan or DA to be partisan. You know, I think the sheriff still.
I think it's constitutional statewide.
They're
the sheriffs and DAs right now are partisan statewide, and it would take a constitutional amendment to go non.
I know SGs. You're probably right on the DAs, but I know. Yeah, I'm sorry, but the SGs some. So I say let the counties decide.
Thank you, Representative Reeves. Let's see, is this Representative Neal?
Thank you to the chairman. Just to be clear, in respect to my colleague, Mr. Fleming, District Attorney Tasha Mosley has been doing this a very long time, to include when I was policing and being a detective in the county of Clayton, and she's been doing it well for a long time. I also think it needs to be stated that our county has been overwhelmed with lawsuits for a very long time, and even through that, she has persisted and gotten the job done and done well. So she also cannot account for her fellow DAs and their views and what they will or will not prosecute. So much respect is due to her, since it is respect that she has earned. So for the question,
Thank you.
do you agree that using methods currently available, if there is an issue with any indiscretions with any prosecutor, that they need to be fearless? The bodies that want to bring articles need to be fearless and use the means that are currently available to handle these issues, instead of using this bill as a cover for those afraid to bring articles.
I agree completely.
Thank you, ma'am.
Thank you, Representative Neal. Any other questions for Madam DA? You don't have any other questions. Thank you very much
Thank
for your
you.
testimony. District Attorney Sherry Boston.
Good afternoon.
Good afternoon.
I am glad to be back here. I will try to be very brief because I've spoken before.
Appreciate that. We appreciate that.
But there was a
But
couple.
we enjoy hearing from you.
Thank you. There were a couple things that I just kind of wanted to point out that I didn't get a chance to elaborate as much as I did last time. And to Representative Sands' questions and Representative Reeves' questions, I think I want to start there with some of your concerns that I think are absolutely legitimate, which is we have a JQC for judges. Why shouldn't we have the same for prosecutors? I'm going to submit that we do. And that's what I want to talk to you about, which is the state bar. I've heard a lot of things, and there have been a lot of questions, and I can answer a lot of those about has a DA or an assistant DA and or both ever been brought before the state bar alleging allegations of misconduct, which for us is the Georgia Rules of Professional Conduct. I can unequivocally say the answer is yes. I can say that because I stated in this last meeting that I spent 8 years on the investigative or the disciplinary board. There is a process, and that's just one board. I can tell you that there were some public and some private. As we know, all of these operations, including the JQC, have some process that we don't know about because it's not deemed public until until complaints are officially charged. But we know that there's a lot of things that happen that we don't know why because it's not allowed to be made public under all of these bodies' rules. The state bar operates in the same way. So I can't tell you about private actions that were confidential, but I can talk to you about public actions that are no longer confidential. And I can tell you right now to this day, there is a former elected DA who had charges brought against them by the state bar. They fought those charges. While they were fighting those charges, that DA was removed by the voters and voted out of office. The state bar has continued with that prosecution, and that DA has a lawyer, that former DA has a lawyer and is fighting those charges because the bar has said, you have been removed from office, but you're still a lawyer. And by the way, that former DA is now working in another DA's office in a high-level position. And the state bar is still moving to disbar that particular person because they believe that their actions while in office violated the rules of professional conduct. So I say the state bar, as a person that has worked closely with the Office of General Counsel, does their job. And as DA Mosley said, there's due process. So this DA has the right to due process, and as does any person, and we don't want to take that away. But to infer that there is no one policing DAs or Solicitor Generals, elected DAs and elected Solicitor Generals, is not true because we do have that body. And the difference, I would say, the JQC in this is when we talk about having a process already in place, we have one in place. In fact, when I got back to my office the other week from testifying, I went into my mailbox and I had 2 letters from the State Bar of Georgia that at the very bottom were marked confidential on the front. Now, I've received these letters before, so I knew what it was. In that letter was a letter closing out an examination. Any of us that have been doing this long enough know that there are inmates that file charges against me on a pretty regular basis with the state bar because they have a right to bring a complaint. Both of those complaints, I was getting a letter being told that they have been found to be unsubstantiated, but that the complaints had been made, that I had violated their rights in some way, shape, fashion, or form. Now, these were 2 complaints that I never had to address because the state bar found with their process that the allegations did not rise to the level. However, had they risen to the level, I would have been required by the state bar to respond. Now, let's be clear. The state bar can't remove a DA from office. However, the state bar can suspend or disbar, upon the Supreme Court's approval, that district attorney or solicitor general. And let's be clear, if you are suspended or disbarred you are ineligible and unable to continue to serve in that role, and ultimately are removed. But I want to be clear that their mechanism is they can't say, we hereby remove you. That would be exceeding their authority. What they can do is say, but you're not a licensed lawyer, and the rules of the state constitution say, in order for you to serve in this role, you must be a licensed lawyer. That's the distinction. Keep in mind, the JQC monitors all judges, because not all judges, including the one that I prosecuted as special prosecutor for the JQC, that judge was not a lawyer. So I was the only person outside of impeachment that could do anything about removing that person, because the state bar could not touch that person, because that person was not subject to the Georgia Professional Rules of Conduct. So I just wanted to give that information and outline that, because I'm intimately familiar with that process, and I want everyone to be informed about what the state bar really does and has done.
Thank you, ma'am. You have a question, Representative Saines?
Thank you for your testimony. It was enlightening in terms of the bar process. Is the state bar a public or private entity?
The state bar is a private entity, as far as I know. Please don't, I'm sure there's, and I see Thomas Worthy in the room, and I know he used to work for the state bar, yes, and can speak to that.
The bar is an entity of the Supreme Court.
Thank you. Is there any method in terms of the bar? Correct me if I'm wrong, but there is no method for for a Georgia citizen other than a member of the bar, an attorney, to have input on those on the Committee of Oversight and Disbarment. Is that correct?
No, actually, there are 3 lay people on the investigative arm of the state bar's disciplinary panel. I can't speak to the review panel, but the disciplinary panel has 3 lay people.
Has the state bar brought any charges against a district attorney for lack of prosecuting specific crimes?
If the level of that rises to the level of a violation, if they deem it to rise to the level of a violation of the Georgia Professional Rules of Conduct, then that would be the answer to that question. Again, I can't speak to what's on their dockets right now, but if it's a violation of the Georgia Bar Rules of Professional Conduct, they would have jurisdiction over that.
I appreciate can they. My question is, have they? You spoke to the bar being an adequate source of regression to the voter's decision, which is a high level. But to your knowledge, have they taken action against a district attorney, elected district attorney, for lack of prosecuting a specific crime?
The 8 years I served on the committee, I can't recall seeing a case of that nature. I can't speak to what's happened since I rolled off or what happened before I came on.
Thank you.
Thank you, Representative Saines. Representative Reeves.
You brought up a situation where a former DA under bar investigation was hired by another DA.
Correct.
I'm going to go ahead and, since this is a hearing, get that out there. Which DA's office hired a former DA who was under bar investigation?
Well, the district attorney it's public information was Natalie Payne, the former Augusta district attorney who was elected, was removed from office, but is still facing that bar complaint.
And which DA hired that former DA who was under bar investigation?
Currently, that DA is working down in the New Columbia circuit.
Okay. And can you identify any instances of the state bar suspending or disbarring a DA?
Yes. I don't have my file with me, but there are 4 public, and when I say public, I mean the Supreme Court has issued orders against DAs and elected DAs, and keep in mind we're also talking about non-electeds. There are 4 instances that I did in my research where it happened, yes. And there have been others where there has been private discipline, right? Because not all discipline is public. It only becomes public if a complaint is filed.
Were those in
Publicly.
the last decade or 2 decades?
Yes.
All right. And did those DAs have more than a year left in their term when they were disbarred or suspended? Or was it after the fact, or with a short period of time left in office?
I'm going to say yes and yes, because again, we don't look at election cycles. And again, when I was on the disciplinary panel, we look at the conduct, because regardless of what office you hold, you're still a lawyer. So you could leave DA being tomorrow, and we're still regulating the conduct or very specific about what you did, and whether that allows you to continue being a lawyer. So I can't. I didn't examine the exact dates.
Here's the reason I asked that. The Albany Judicial Circuit, when we were adding a judge down there, the statistic they gave is they have a 10,000 case felony backlog due to COVID. So in 3 years, they've accumulated a 10,000 case backlog. So if you have a bad DA and they're in there for the next 3 or 4 years, that could have disastrous consequences that are going to take many years to get out of. And so I'm looking for a mechanism to clean up problems quicker than the status quo.
I get that, and I think that's a legitimate concern. What I can say, my concern is that how are we creating the metrics of what it takes to do certain things? Backlog, that's one example. Again, we were all handed a COVID backlog that there was no playbook for. It's not like we'd been through this before and we can say, oh, this is how we get out of it. We all had to individually figure out, based on our individual jurisdictions and how they were operating back, and who was trying cases and how many judges we had. And so my concern is when you have a committee or a commission that is going to try to figure out if a DA has managed something well or handled a backlog well, what kind of metrics are you using? Just like DA Mosley talked about vacancies. And I heard some testimony the other day about, well, if you have these vacancies, what does that say about your management style? And Tasha was kind enough to say that she's not a poacher. I am. All right. I will raise my hand, and all my fellow DAs will know that I have poached a lot of people, and they're all nodding their heads behind me. I know. And that's in part because I have, I will say it right now, I have the best CEO and board of commission, and they have funded me in a way that allows me that my starting salary is not $55,000 a year. My starting salary is $90,000 a year. So rest and believe that there are DAs from these other offices that are struggling with their backlog as much as I am, who aren't sitting here before this committee fully staffed. And I will say I'm aware that my friend Chris Carr in his hearing talked about how I poached someone from his human trafficking unit to come work in my office because I have those supplements. But I just want to remind you that not every DA in the state gets county supplements. So that state salary becomes really important because those folks that don't have the extra resources can't work beyond the $55,000 starting salary. So, people are going to make choices. And a lot of times when you're coming out of school with a lot of debt, it's about money and location. So thank you.
Thank you, Representative Fleming.
Thank you, Mr. Chairman. Now, we're talking about Michael Thurman, right? Your CEO who will
Yes.
fund you, right?
Yes.
A former member of the House, correct?
Yes.
All right. Well, that explains a lot, doesn't it?
He understands what it takes to run good government.
He was trained well right here.
Yes.
On this committee, actually. Representative Thurman served. Good fellow. I want to ask you more about this bar process that how long has it been since you've not been on the disciplinary panel at the state bar?
Probably, I think about 24 months, not long, although it seems a lot longer. It was a lot of work.
On the panel when you recommended as part of the panel that this DA you're discussing be brought up on charges and disbarred, correct?
Yes.
Okay. Tell us about the special master process and how that works.
Ooh, so I will tell you that's a little bit out of my breath because that process is beyond the investigative panel for which I was a part of. However, I will say when someone enters that process, to my knowledge, it's like a mini trial, so to speak. And that special master will make a decision and or recommendation. And of course, all of these, no matter what, go before the Supreme Court if it is a public discipline.
But I agree with your supposition that this special master, Representative Reeves, in answer to your question, a special master was appointed by the bar to look at this very case that the DA is talking about. And do you know what the findings of that special master were?
I am not aware. It's my belief, I think, that process is still going on.
I am very aware of it. Let me tell
Okay.
you what it is. The special master thought it was ridiculous the committee, your committee, that brought up this particular DA for charges and suggested that they be dismissed. Although the same bar committee went after that same prosecutor again with very similar same charges after the special master appointed by the bar said it was terrible that they had done this to a prosecutor because the prosecutor had done nothing wrong. And the summary of the situation is this: that prosecutor they went after was very aggressive at going after criminals. This bar committee has done nothing for prosecutors who are not going after criminals. And that's the summary of the story behind that story.
And respectfully, I would disagree, having known the facts and circumstances when
So
I
the
was asked to
special
read
master is wrong?
I didn't
in
say
his
the special.
summary?
I said I disagree with how you've categorized that we went after this person because they were aggressive. I
Right.
absolutely disagree. There was some documented constitutional issues.
So tell me how you went after Ms. Gonzalez in Athens?
I am not currently on the investigative panel, and I don't know, and I can't tell you if any allegation has violated the Georgia rules of professional conduct. I can tell you the circumstance that I'm speaking of. The allegations were a violation of the Georgia rules of professional conduct.
Except the special master found out that you were wrong on that, didn't he?
The special master made a different decision, yes.
That's correct. And also, zero has been done on Ms. Gonzalez to answer that question.
And to my knowledge, I don't think any charges have ever been filed against Ms. Gonzalez, and I have not heard of anything or any allegation of a violation of the Georgia rules of professional conduct.
Do you think Ms. Gonzalez has done anything wrong?
I have not heard anything that's a violation, because you're asking me wrong, and wrong is the wrong word, because what we're talking about is a body of rules that you must follow under the Georgia rules of professional conduct, which all lawyers have to adhere to. That is the standard. I'm not aware of a situation that violates the Georgia rules of professional conduct.
Which says exactly why we need some more oversight over your group, DA.
Thank you, Representative Fleming. Representative Kendrick?
Thank you. This is my DA from DeKalb County, and respectfully, I would disagree with my colleague, because it seems like we should listen to somebody who was actually on the panel and heard all the facts, as opposed to making any judgments from this seat right here. So thank you for serving in that investigative panel. So I guess my question is to clarify, because the DA earlier, and I asked this question previous in a hearing, it seems like we're stacking on more and more oversight. So I want to be very, very clear about who is oversight of the judges, since we keep comparing that, and who has oversight of the DAs, to see how many layers it is that we're going through. So correct me if I'm wrong. So for DAs, we have the electorate. We have the AG that can bring charges, correct? We also have the state bar.
Yes.
And then we have the Georgia legislature. So
correct.
Am I missing anybody who has oversight right now of DAs?
No, you've stated them all.
Okay, and then for judges, we have the electorate. The attorney general can bring charges. The Georgia legislature can go through the same impeachment process. So the only thing that is missing is the difference. Is the state bar between.
Correct. State bar cannot regulate the conduct of a judge. They don't have that authority. They can only regulate the conduct of a lawyer.
Mm-hmm. Okay. And all DAs must be barred lawyers.
Correct. Unlike judges, where that is not a requirement in certain populated jurisdictions, all elected DAs and all elected Solicitor Generals, regardless of their jurisdiction, size, shape, or form, must be good standing members of the bar for a set number of years before they are allowed to be in that position, either appointed or elected.
Okay, and even though we don't have a member of the state bar, the lobbyist from the state bar here, our state bar is a mandatory state bar. So it's not like other states where you can choose to be a member of the state bar and have a license. It is a mandatory state bar. So good standing bar members have to be a member of the state bar, correct?
Yes, bar membership in Georgia is a mandatory process. Yes.
Thank you.
You have no other questions? Thank you.
Thank you.
Solicitor General, Forsyth County, Mr. Bill Finch.
Thank you, Mr. Chairman.
Yes, sir. Good to see you again, Bill.
Good to see you, members of this committee. I spoke with you once before, so I will try to keep it brief in case I get going. Sometimes I'm like a runaway locomotive, so I trust you'll cut me off if I get that way.
I'm going to give you 4 minutes, Bill.
Okay, thank you.
Just in the interest of time.
Okay, thank you. There are a couple of things that I would like to point out to this body is that I'm mad, just like you are, at prosecutors who get out there and make political speeches. I think it violates the very oath of office that we take. It is very important to me when I raise my hand and swear to uphold the laws of the state of Georgia and the Constitution of the state of Georgia and the Constitution of the United States, and that you will discharge those duties. It means something or it doesn't mean anything at all. And so I think these political speeches are bad. Not only are they bad, I think they violate the very oath of office that you swore to uphold. And so I think that 1610-1 adequately covers the violation of that oath of office. I would encourage anyone here to file a complaint with the Attorney General if they feel like somebody has violated their oath of office. Additionally, public officials can be investigated by special commission, and that's 45-5-6, and prosecutors can also be removed for conviction of a misdemeanor, and that is 4511-4. I would also urge the members of this body to remember what it is that they run on when they go back to their local electorate, and that's limited government, local control, fiscal responsibility, and respect to the ballot box. And those are the things that we slam our fists down when we're talking to the people that support us, and we say that's what we stand for. And I would hope, as we're looking internally as to whether or not we're going to vote for this, that we would say, does this bill, is it reflected in limited government, local control, fiscal responsibility, and respect to the ballot box? And if you can answer that, then yes, then go ahead and vote what your heart tells you to vote. I don't think we need anything. I keep hearing about everything that's inadequate, but nobody has filed any complaints with the Attorney General's office that I'm aware of that somebody has violated their oath of office. It is outside the purview of this committee meeting today, but as to the issue of the nonpartisanship, I would encourage anybody that votes for that to contact your local party to determine where they get their funding from. I write a check for about $4,500, and my local party gets a good portion of that, and they're struggling for money. So I would encourage anybody that's thinking of supporting that to remember that. Thank you, Mr. Reed. Any questions?
You have no questions.
No.
Thank you for taking time, Mr. Solicitor.
Thank you.
We'll probably see you after session, I'm sure, up in Forsyth.
Especially on that constitutional amendment.
Yes, sir. Yes, sir. Yes, sir. Noted, noted. All right. I think that's it. What's the pleasure of the committee? Got a move to pass. Second. All those in favor say aye. Aye. All those against, same sign. No. Ayes have it. Congratulations. You're on the full. All right. At this time, we are going to recess for full committee. We're going right into the full committee.
If you got to go to the restroom, just wait till we go into it real quick. Or, excuse me, we'll consider ourselves in full committee now. If you need to go to the bathroom, just make it quick. Stretch your legs real quick. But we're going into full Judiciary non-civil committee. We'll come back to the Leverett subcommittee after the full. All right. First bill we have up today, if I can find him. Tell you what, we have Representative Mathiak out there. All right, Chairman Leverett, are you ready to present your bill? All right. Okay, never mind. We'll come back to Representative Mathiak. Chairman Leverett, we'll hear House Bill. Or Karen.
I was trying to get in, sir.
Okay. All right.
Thank you.
All right. Well, there she is, Rob. Just hold on. We'll hear yours in a minute. All right. Representative Mathiak, go ahead.
Thank you. Thanks for hearing my bill today. I'm bringing to you House Bill 166, and I was asked by my magistrate judge in Spalding County. She still uses a constable. And the bill that was written previous to this, you had to live in Spalding County, not just the jurisdiction or the Griffin Judicial District, which would have included Lamar and Pike and Fayette. So all this does is allow for the whole jurisdiction rather than one county for the residents of the constable.
Okay. Committee, we heard this bill last year. Any questions? Any questions? All right. Representative Fleming.
Thank you, Mr. Chairman. Chairman Mathiak, we've passed this bill, what, 3 times now?
I think so.
And maybe the Senate will get it this time. At the appropriate time,
so.
Mr. Chairman, I'd have a motion when you get ready.
I'll entertain that motion right now.
Do pass.
We got a move, do pass. Second. Move second. All those in favor say aye.
Aye.
All those opposed, no. All right. Congratulations.
Thank you
We'll
so
sign you
much.
form. You're
Let's
welcome.
hope. Let's hope, right? Thank you.
All right. Chairman Leverett.
Thank you, Mr. Chairman. Would you like me to get in the hot seat to present?
You can present it from right there.
All right. I believe the thank you committee will view this as somewhat of the shoot up in amongst us. One of us got to have some relief bill because we've heard this several times now in subcommittee, and we've made a number of changes to it. But this bill, the intention, I believe, I'm sorry, House Bill 227. That's a substitute LC 480871S. It would, as revised, it would take the statute on criminal damage to property in the first degree and create a second or a special subclass that would be criminal damage to critical infrastructure by force or violence or by electronic means with respect to electronic infrastructure, and increase the potential penalty from 1 to 10 years to 2 to 20 years. But it's only as to that particular crime. Then we've also sort of cleaned up an existing code section that dealt with damage to critical infrastructure, but it was not really related to the sort of damage we've seen lately. It was related more to theft of the services provided by that critical infrastructure. And so I believe in subcommittee we went through a couple of versions, but I think we've got one now that has some good defined terms, and just make sure that our prosecutors have a tool to deal with some of the events we've seen lately where people are damaging substations and other kind of infrastructure, not necessarily for a purpose of domestic terrorism, which requires proof of certain other elements, but for other reasons that wouldn't constitute that crime. But the damage does have very wide and broad ranging effects on many, many people, as we saw in North Carolina back in December, when about, I think, 40,000 people were left without power during one of the worst cold snaps we've had here, at least in my memory. And so this would give us another opportunity to deal with that, and also hopefully deter people from that kind of conduct. And if it doesn't deter them, at least we can punish them appropriately given the kind of harm they're causing.
Good job. I feel like I could recite this myself, Chairman Leverett, in my sleep. Number 13.
Thank you, Chairman. Just a quick thing. Isn't it true that my EMCs, as well as cable companies and telecommunications companies, have all reached out supporting this measure and thinking it's one of the most important measures they have this year?
Thank you. That's my understanding. Even the chambers, state chambers supported as well. Thank you.
All right, whose number? Sorry about that, Rob. I cut you off. Okay, I see no other questions. Anybody signed up to talk to the bill? Going once, going twice, done. All right. Any discussion? See no discussion. Do I hear a motion?
Make a motion. Second.
All right. Motion second do pass. All those in favor say aye. Aye. All those opposed, same sign. Congratulations, that passes.
Thank you, Mr. Chairman.
We'll get that taken care of for rules. All right. Representative Cameron, how are you?
Fine, sir. Thank you for allowing me to come forward.
How's everything up towards Tennessee?
Independent State Aid is in good shape today, sir. Thank
Good
you for
deal.
asking.
You keep them volunteers at bay. Tell us about your bill.
Yes, sir. My bill is HB 327 LC 480794. This bill came about at a request of the Lookout Mountain Judicial District. We had a situation where a young lady went to live with a grandparent and a step-grandfather. Unfortunately, the step-grandfather initiated a sexual relationship with the young lady, and after it was discovered, there were efforts by the district attorney to prosecute, but he could not under 16.622 of the official Georgia code because step-grandchild is not listed. So we make one change to the law to include that grandfather, step-grandchild relationship. That's it.
Okay, thank you. Y'all had about the same time. Representative Fleming.
Mr. Chairman, this bill made a whole lot of sense in subcommittee, and I have a motion when you get ready to accept one.
Thank you, sir. Representative Neal.
I had the same motion.
Golly, let's see. Representative Miller.
Thank you. I did have one question for you. So the prosecutor was unable to prosecute this as any other sex offense, stat rape, child molestation?
She was of age. She was 16 when the relationship started, and she was, I guess, 17 and a half after when the relationship was discovered, and there was no other way to prosecute, in my understanding, from the district attorney's office.
Okay. And this was not a forcible.
No, he talked her in, basically over time talked her into a relationship.
Okay.
And she got into it, couldn't get out, kind of thing.
One more follow-up, Mr. Chair. Do you have any sense of how many other states include the step-grandparent relationship in the incest definition?
I know that Tennessee has something similar in their law, but I don't know exactly how many. I do know that just doing a little bit of cursory research that a lot of the incest cases in America, and I can't give you an exact number, are in a step relationship.
And last question, was there a similar concern with adopted kids or making any other modifications to the incest statute?
Not at this time.
Okay.
That was specifically this is what sprung it.
Step-grandparent?
Yes, ma'am.
Thank you.
Thank you.
All right. So no other questions. Any discussion from members of the committee? God, y'all are a quiet bunch today. What's the pleasure of the committee? All right, move to pass. Second. All those in favor say aye. Aye. All those opposed, same sign. Congratulations. We'll sign it. You can go to rules.
All right. Thank you, Mr. Chairman.
Thank you. I want to take just a minute. I've got a constituent here with me today, Miss Mary Collins, who I did not realize when I spoke to the Bremen High School class of Miss Hightower, Judge Hightower's wife, that Miss Mary's aunt is our own Angela Holland. So, Mary, welcome to Judy Non-Civil. You are getting a upfront look at the criminal code, so amongst others. So anyways, we're glad to have you. All right. Representative Franklin, I hear you got a bill that you want us to hear today. And
Yes,
that's House Bill 302.
Yes, sir. Thank you, Mr. Chairman, members of the committee. This is House Bill 302, and I don't know if you need it, but it's LC 480815. This bill is pretty simple. It basically just clears up some of the language to allow the judges to be crystal clear that they have the discretion to either make a protection order temporary or permanent. From what I'm understanding is 16-5, that's 90, already has the language in it. And this bill would allow 16-5-94 to be able to include that language as well.
Representative Franklin, when you brought this bill to me, we had a discussion about crayons, didn't we?
We did.
Do you remember what that specifically was about?
No, sir, I don't.
That we had to specify this statute so it could be applied the way that it's already written?
That's right.
But it'll leave no doubt, correct?
That's good. That's
Okay.
correct.
Any questions from members of the committee? Number 17, Chairman Leverett.
Mr. Chairman, I just would like to note that Representative Franklin sat through one of the longest Leverett subcommittee meetings I hope we ever have to present what was such a concise, simple bill. I just wanted to recognize him for his stamina.
Thank you.
In front of the full committee. Thank you.
I would commend that too. I know where his undergrad is, so I'm
I appreciate that.
held true to the ideals of the Citadel. Any other questions? Representative Franklin, thank you for bringing this bill. What's the pleasure of the committee? Move to pass. Second. All those in favor say aye. Aye. All those opposed, same sign. Congratulations. You're on the rules.
Thank
This
you,
will be
sir.
your third bill?
Hopefully. Yes, sir.
Good Lord. Okay. All right.
Thank you.
Thank you. All right. Let's see. Chairman Powell. I'll have to also commend Chairman Powell. He stuck it out with us the other night, and we appreciate that very much. House Bill 196. What LC number are we working off of, Mr. Chair?
I'm not sure. I just had to borrow one from Representative Miller over there. I'm suspecting this is 280592S. All right. Well, I might want to let Ms. Miller have the copy I borrowed from her.
Go ahead, Chairman Powell.
Thank you, Mr. Chairman and ladies and gentlemen. This is, I think y'all have seen me on this bill a couple of times. This may be the first time I've ever had a bill in Judiciary that passed the full committee, went to rules, was sent back to the subcommittee, and we had a roaring good time the other night. As I had said last night, normally Judiciary isn't a place that I like to hang my hat often, and I've certainly done enough of that this session. But it was all worthwhile watching the subcommittee's action as we watched the adversaries to this bill, who prompted every idea that they could. None of them seemed to carry a lot of validity. But in this bill, there were some changes from the original bill, and it's pretty simple to go through. Section 1 still puts them under the Administrative Procedures Act. Section 2 puts any appeals and such through the, lets you go through the business courts. Section 3 basically allows the growers that are growing the product and refining it down to actually have a retail location on their spot, which would give it a few more in the state. At the end of Section 3 on line 105, this allows the dispensing locations to sell any other THC oil product from any of the other producers. Now, the way that was explained was that all of these growers have a different variety, different techniques, so one might work on or has a product that might help one illness or condition where the others won't. So they can basically sell whoever's got whatever for whichever condition. You get into section, let's see here. Section 5 and 6, this gets into the original language of the bill, if you remember, allowed for the protesters that had standing to have a license. This leaves that language in there, but it's still may instead of shall. Section 8, this gets into a issue that I had discussed with members across the hall at some point if it goes through it, and the question was always brought up, well, how do we move forward with other licensees at a given basis? This basically sets this into the patient level of the medical cannabis cards. You know, in the last, since this thing has drug on for so many years, 7 years ago we passed this. People in due faith, they went with good faith, they went to their doctors, they were diagnosed with one of the conditions or whatever. They paid for that, they went and got a medical cannabis card from the health department. That was 7 years ago. 4 years ago, 4 sessions ago, much to the joy and glee of the legislature, we thought we were doing something that was going to get this product moving forward. 4 years ago, ladies and gentlemen, it still hadn't happened. Because of certain things that happened to the Cannabis Commission. It was drug out, there was issues made, there were protests filed, and I have to say, from the position of chairing regulated industries and hearings we had last year, we had to ferret out from the protesters and from everybody else. We had to ferret out the process. And it was absolutely the worst process that we could have imagined at that time by looking at comparable bids and information. I mean, it just defies any explanation. But, you know, I'm past the point of criticizing the bureaucracy of this state. It's time that we move on. And that's what this basically does. You go on down, it's more language on the business courts in section 9. And then, of course, you've added 2 new diseases to this, ulcerative colitis and yes, sir. That's ever how you pronounce that. And that was put in, and that, ladies and gentlemen, is what this does. I'm certainly open. I'm at the will of this committee. You know, it's not what I had originally proposed. I guess, unfortunately, I'm more of a straight shooter than I was anything, and I was going for the direct way to curing this thing in the original bill that y'all passed out. In that original bill, it would have given the protesters a license. And that would have got them out of the court system. It would have got them out of the Court of Appeals. It would have got cleared the decks on everything so that we would have got onto this. This is a different way of doing it, and I think it's probably going to take some tweaking at the will of this committee and through the process to get it cleaned up and where it moves forward. That, ladies and gentlemen, is what I'm asking the committee to pass this on forward. I will bow to the wisdom of the committee on however y'all wish to clean it up or leave it the way it is. But it needs to be moving forward. As you know, we're running out of days. And this is a very serious issue to the people of the state of Georgia who have created a situation that they have faith in us. You know, those people who don't think that medical cannabis has a role, well, I say that defies the natures of a lot of the folks in science and medicine today. And that, Mr. Chairman, is the story of this bill.
Thank you, Mr. Chairman. Appreciate your hard work on this. I can tell you that I had a couple of new members talking about your masterful handling of the subject material, and I always tell everybody that if you want to see a chairman that knows their material, look at Chairman Powell, so thank you.
Well, I take that as a high compliment.
Yes. Any questions from members of the committee? I know, and I appreciate a lot of y'all having sat in on the subcommittee that heard this. That's, if you've got the time and can do that, I always appreciate y'all doing that. It makes this process much better. Number 6 over there, is that Representative Fleming?
Thank you, Mr. Chairman. Chairman Powell, yeah, I want you carrying my bills too. The question that I have is still the same one I mentioned to you the first time we talked about this. We've had a long, drawn-out process that evidently has had some problems. I don't think anybody disputes that. and I want to make the situation better, not worse. And under sections 5 and 6, it looks like we're going to give out more license than the original legislation. I just want to be clear, first of all, on how many more can now be given out than the first process that we started. I'm reading the numbers there, but I want to put it in the right context.
Well, this is a clean sheet. I don't have my notes, but if you look in section 5 and 6.
Yes, sir, 5 and
I
6.
can only compare to the original bill. The original bill, you have 2 that were granted Class 1 licenses, and they're in operation today. You had 4 that were tentatively granted, but they're on hold due to the TROs.
Okay.
Then there were 8 at that time, and I think it's gone up to 9 because there was 1 that didn't participate in the actions, and they're held in the courts, but went a different direction, and they have cases pending also, separately from the rest of them. So I think it goes to a maximum of 15 licenses.
So we're going from what to what? First process, how many?
6.
Second process, how many?
Well, the original handiwork 4 years ago was the governor's office and the study committees recommended 12. Went through the legislative process. It left the House, went to the Senate. They wanted 3. It wound up at 6, which was still drastically under what was supposedly the right number.
So the legislation we passed
6.
initially was 6,
We
okay.
passed 6.
And what does this piece of legislation
This
do?
would take it to 15 total.
15 total, okay. So really 9 more, basically.
9 more, which would be the exact number of the protesters. But in this language, it doesn't mandate that it goes to those protesters, and that maybe should be some of the language that.
So I have been able to be in some of the hearings, and I have missed some because of other committees I had to go to. But let me ask you the same question, see if this process has led you to an answer or maybe a different one. If I'm one of the original people that got this license, and the state after that process awards more, I'm wondering if those original folks are now going to file suits because we had a process and then we basically changed it. Any insight on what this legislation is going to help or hurt that situation?
Chairman Powell, can you pull that up a little bit closer to you, the microphone?
I'm sorry. To my good friend, as you know, I'm not an attorney, but I am as dim-witted as I can be at times. I do pay a lot of attention. And I have listened to an awful lot of you attorneys that have shown me a lot of things and taught me an awful lot over the ways. But, you know, we knew that there was going to be a barrage of the folks who were opposed to this bill. And I think you need to know why they're opposed. Right now you got 2 Class 1s that have been building out. They're ready to start selling. They have a monopoly or a biopoly in this state right now. And for every day that goes by that they're permitted without the rest of these folks getting into it, is the tune of millions and millions of dollars in profit. There's no competition to them right now. So when subcommittee heard this language, you know, the guys with alligator shoes and they were slick talking, but at the end of the day, there's case law galore that the state legislature has the right to pass legislation as long as it's not unconstitutional. And that argument about diminished value, well, there's nothing says that at any time we can't add more numbers to anything. So, you know, we are the legislature, and as long as we pass legislation that's not unconstitutional, then there's no grounds for a lawsuit.
Number 16 over there, is that Representative Byrd?
Thank you, and thank you for all your hard work on this bill. I'm just still trying to get. So if you go to a physician, they give you a card so that you now are able to get medical marijuana. Is that correct?
That is correct.
So now when you open these stores, who will be able to go? Only the people that have the cards?
Only the people who have been deemed a medical necessity that meet one of these. If you look on the last sheet or two, you've got probably, I don't know, 20 different diseases here. Once a doctor determines that you qualify for that, then they sign off on the right to possess medical cannabis, low THC cannabis. Then you go to the health department, the county health departments, and you then file, I think it's a $35 or $40 charge or something, and they give you a nice shiny little card that says that you're eligible. You take that card, and when these facilities are open, then you go to them and then you buy whatever the product that you need.
But only those persons that have the card.
Only those persons that have the card. This isn't like going to other states where it's just basically open to any and all people. You got to prove you have a disease, or a doctor has to sign off on it, and then you go to go to the facility.
So further follow-up, please. So originally, which I was not here at the time, it was for, I think, approximately 12,000 people.
I don't remember how many there were at the start. You know, I thought it was somewhat interesting at the time that we had higher numbers of people at that time that had possessed them, because they were actually thinking this thing was going to pass. It was going to be into effect. So they built up a certain number, and then in the last few years, because of the failure of the system, they've let them expire. So the number is down. I think there's still some 20-something thousand of these cards maybe in effect right now. But, you know, it has the potential that once things are in operation, you'll see those numbers drastically go up in number.
So do we have any idea? I mean, a million people, 250,000. Do we have any idea?
I don't think anybody would know at that point. It'd just be a wag at that point.
Thank you.
Thank you.
Representative Kendrick.
Thank you, Mr. Chair. Going back to Representative Fleming's question, Representative Powell, you'll remember that there was an attorney who produced a contract that stated it had the terms in there stating that the people who were awarded the licenses signed a contract saying that rules could be changed, the legislature could come in and change the law, and they consented to that in that particular contract. Now, obviously, you can't sue people, stop people from suing, but I assume if they tried to do that, it would be dismissed since they did sign that contract.
And thank you for reminding me that, yes, that was produced in the subcommittee. That part of the application process basically signed off that you have no rights to sue any further because it's the right of the state to increase numbers.
Okay.
Maybe one of the few things that was done right in that original bill, quite honestly.
Looks like that's all the questions. We got anybody signed up to talk to this? Anybody? All right, Attorney General Emeritus, good to have you with us again. You were here the other night pretty late. Mr. Attorney General Emeritus, what I'm going to do is I'm going to give you 4 minutes, and whenever you hit 4 minutes, that's a hard stop. So good to see you again.
Good to see you. Thank you. As I look at the new version, it seems to me Section 8 is the one that's most different. If Chairman Powell would have presented to you what y'all moved forward at the last meeting, I wouldn't be talking to you. Section 8, starting on line 189, I think is an issue because once again, we're rewarding the folks that sued the state with automatic licenses. And Mr. Chairman, I apologize, I only have 4 or 5 of these. That's the scoring that's on the GMCC website. If you go down 4, just 4, you get to a score of 770. My client had a 970 out of 1,000. If you go down 4, it's 770. I think under Chairman Powell's bill, you'd go down 6. And my concern is if you're giving people automatic licenses, rather than having the Cannabis Commission evaluate their competency, I think that's a really poor message that you're sending the state of Georgia and its citizens. If the GMCC finds that they are qualified, competent, I'm not talking to you. But when you automatically give licenses to folks that sued the state and you're telling GMCC that they have to go by that list, I'm not really thinking that scores in the 700 and 600 should be receiving a medical license to produce, grow, and sell. And that's the limit of my comments, Mr. Chairman.
Thank you. Any questions for Attorney General Emeritus? You got one?
Yes.
Okay, gotcha. Oh, well, hold on a minute. We found one. Vice Chairman Reeves, I'm trusting this will be a brief one, right?
Absolutely. I missed that on the presentation. If you can tell us a little bit more about what you understand the change to be to Section 8 from the subcommittee the other night.
So Section 8 in the version that came out of the subcommittee literally just said you give additional Class 2 for every 5,000 and an additional Class 1 for 10,000. When you look at the bill in front of you, starting on approximately line 189, that's totally new. This is the first time that language is in your bill. And what that says is that the initial licenses are awarded, but then pursuant to the competitive application process, that post-award process should be viewed next for the new licenses. So that means you're going down on that list for their scoring. So under this bill, you'd in theory be going down at least 6. I candidly don't know what the number is going down 6. I know 4 is 770. It seems to me that our patients in the state deserve the highest quality product. And that's my point. When you're rewarding folks that sued the state, rather than having the state agency assure that the product is safe and reliable, that's a problem. That's my point. And as I said, if he didn't add Section 8 in this bill, which rewards the folks who sued the state, I wouldn't have testified. Thank you.
Thank you. You know, growing up, you hear about folks that are in statewide office. And what year were you elected?
2010.
2010. So I was finishing up freshman year, going into sophomore year. You never think growing up that you'll have people that are former statewide officials that come speak before your committee, and I want to thank you for being with us. Appreciate that. Thank you for the work for our state. Anybody else signed up? We got somebody over here. Somebody. Oh, Les. Hey, Les. Sorry. Didn't see you back there at first. And let's just, we know who you are, but just for the record, who you are and who you with.
Les Schneider with Wimberly and Lawson, and again, there is no perfect answer today on this. I agree with Representative Powell that the thing needs to move forward, even notwithstanding the objection from Representative Olin, from Attorney General Olins. He is assuming that everything that was done by the Cannabis Commission and the scoring was correct. Obviously, the litigation questions that. Representative Powell brought before you a bill that would put full closure on it. If we don't want to go with full closure, but at least keep this thing in play to try to come up with the best solution, we would ask to be passed. There is no evidence to suggest that those other scores would make those people not competent to produce the drugs that are being asked for. So we would ask for you to pass it as is and let it work through the legislative process so we can have a resolution to this matter rather than prolonged litigation. The same issue that occurred here occurred in Florida on the scoring issue, and as I pointed out last time, the judge there ultimately awarded it without any reevaluation of the scores. So I would ask that you pass this out as is.
Representative Fleming, you must got good and rested up for this week over the weekend.
All weekend long, Mr. Chairman, all weekend long. Counselor, my question goes to what Attorney General Owens asked.
Mm-hmm.
Do you agree that what is in Section 8 is not what came out of subcommittee?
Yeah, it came out of, not out of the second vote. Out of the first vote is exactly what was in subcommittee, that we awarded it initially. Here it's taking a different approach to say, I think to some extent what Representative Silcox talked about, that as the register grows, there would be additional licensees. But yes, there's a difference between what was passed out from the subcommittee to here. And this is to take into consideration and an approach to eliminate the litigation. If in fact all of the protesters saw that they were going to have a path to a license, that might be a indication of how the litigation can go away and we could move forward with the industry.
But Section 8, as it currently stands, is not the Section 8 that was recommended to this full committee by the subcommittee.
Up to line 189, I think it was. That's when they talked about the 5,000 patients and the 10,000 patients. The additional part, as Representative Powell indicated, that this would be addressing the people who still have standing and how to deal with that issue. But they still wouldn't automatically get it.
I just want to make sure. I want to make sure I understand you.
Mm-hmm.
Section 8 is not the Section 8, the same one that was recommended to us by the subcommittee. Is that correct?
Up to line 189 it was. After that it was not.
So the answer would be It is not, and then you can make comments,
Yeah,
but I want to
from
make sure
one
we're
eight-
on the same page.
Yes, from
Okay.
189 to 201, that was what was in the previous bill. And from 182 to 189, that was in the subcommittee bill.
Thank you.
Sure.
Looks like that's it, Les. Good
Thank
to see you.
Thank you.
Anybody else? All right. Chairman Powell, I'll give you the final say.
Thank you again, Mr. Chairman and committee members. I'm not quite sure, as y'all may have remembered in the subcommittee, I was very open to the fact that the substitute that was brought to that study subcommittee was not my substitute. I took a very direct course, and I don't apologize if I see a problem that I take a very straight line approach to fix the problem. My distinguished friend, the former Attorney General, has got a client in this, so he's going to find whatever he can. And the argument has been about why we're doing these extra folks that have standing because they protested. They may not have had the highest scores, but they did go through the process. They took it the next step. They filed their protest because they had been wronged in their opinion. And I also think that they were right. I don't know who actually got the right scores. Personally, I don't think any of the scores were given that were right. We know that a couple of the folks, there were some other inconsistencies. And remember, this whole issue was supposed to be, these growers were supposed to be Georgia-based companies. And I hate to dispute the fact that because you have minority participation and you're out of Florida and you hire a former football player and you hire a peanut farmer, that nothing is more sacred than Georgia football and peanuts. That doesn't necessarily make you a Georgia-based company. There was testimony that was given at that time about family members that might have been. I never did get the answer about that because I never saw a lawyer and a person eat up a seat in a chair, in a witness chair, more than they did about people who had been charged with bribery and stuff like that. But it all goes back to what I had told y'all to start with at the last meeting I was here. This is about money. This is about money, ladies and gentlemen. None of these companies have applied are going to win the Mother Teresa Humanitarian Award. These folks are out there to make money and to go forward. And the beneficiary is just like the pharmaceutical companies that deal with people that need their product. People need this product. Now, I'm not sure what was in here. I had to ask for a copy of this, quite frankly, so I don't know if this is what passed out of the subcommittee or not. I can't imagine that anybody could have added something to this. But, you know, I will still refute that claim that these people who file suit, they're the ones that are keeping it tied down right now because they had rights to litigate. They felt they were wrong. They had their investments into this, into their applications. So mine is all about moving forward. Even this isn't my product. It's my total product. Some of it is. But it's about trying to fix this situation. And I would certainly ask this committee to move this bill forward. And if y'all have the discretion, if y'all want to make changes, just tell me the changes you're going to make and I'll explain it.
Thank you, Mr. Chairman.
And I thank you.
Just sit right there for a minute. Hearing that, any discussion? Number 5, Representative Neal.
Yes, sir. Thank you to the chairman. And thank you for the conversation. So being that you said that this isn't the bill you presented prior to, and being that you said we all know that this is not the bill that came out of the subcommittee, would you be open to just taking out the language that you didn't originally, that was not in the original bill from subcommittee?
Of this committee, and I'm certainly willing to live with that to move this thing forward into the process.
Gotcha. Okay, thank you.
Anybody else? All right. Do I hear a move? Move do pass. Do I hear a second? Moving a second. Members of the committee, I'm going to propose an amendment. We just call it the Smith Amendment. I'd be interested to hear Chairman Powell's comments on it. On line 139, where you see may, strike that and make a shall. Then on line 151, strike the may and put a shall.
And I'm sorry, that was on line, what was that one on line?
151 and 159 make the, yeah, 139 and 151, sorry. And then we'll change the mays to the shall, or to shall on line 139 and line 151. Then go with me to line 189, right after the period after 2023. Strike starting at the all the way to line 201. And I can repeat that again, starting at line 189, after the period following 2023, strike starting at the word the, all the way to the period on line 201. And that's the amendment. Take a look at it for a minute. If you need me to repeat it, I understand I have a pretty thick accent. I apologize, I still had my mic on. I learned from my grandfather many years ago in a hayfield, just making little noises while you're working. Helps it go along. It's not always just gospel, it might be a little AC/DC too. All right. Discussion number 18, Minority Caucus Treasurer Roberts.
Thank you, Mr. Chair. This has gone through several reiterations, but is it my understanding that by making the amendments you just made, we basically took it back to what it was in the very beginning?
That is correct.
Okay, thank you.
Minus the mays to shalls.
It
No.
originally had shall, I thought, and now you've taken it back to shall.
No, not the one that come out of subcommittee. You're thinking about the last one before, Phil, sorry. Number 12.
I think it's a correlated point of clarification. The first requested amendment, we're changing may to shall on the licenses already granted. The 4 are already granted, correct?
Mm-hmm.
And then will that be one amendment? 'Cause the second part of your amendment will be a policy distinction.
There's one whole amendment, there's two
Okay,
parts to
thank
it.
you. Appreciate it, just making sure.
Yep. Thank you. Thank you. Bear with me. Okay, strike that back out. We're gonna change the mays on line 140 and 152 to shalls. Representative Fleming.
Mr. Chairman, I thought I had a question, but right now the question is, what is your amendment now?
So instead of on line 151,
Yes, sir.
that's going to stay, 151, that may shall stay a may. The may on 152 will be a shall. And then on line 139, we're going to leave out a may, but change the may in line 140 to a shall.
So practically speaking, what do we just do if we pass those two amendments?
This gives the commission the ability to issue, or requires them to issue 4 additional Class 1 production licenses and up to 7 Class 2 production licenses.
So
Class 2, yeah.
So on line 140, we're changing a may to shall?
Yeah, that's correct.
So it will read, the commission shall issue up to 4 additional Class 1
Yes,
licenses.
that's correct.
All right, here was my question. I know how a commission may issue up to 4 licenses. That means you can issue 1, 2, 3, or 4, or 0.
Mhm.
I don't know how a commission shall issue up to 4 additional licenses. What does that mean?
Yes, sir. Well, if you'll go ahead and read on down in the bill, I'm sorry you wasn't here for part of that conversation. You'll look that these are, I want to say it's under Section 8, the part we're leaving in there. Those are issued with an increase of every 5,000 patients for Class 2. And then for every 10,000, increase of 10,000 patients, that's an additional Class 1 production license. Any other questions?
My question still is, Mr. Chairman, I understand how a commission may issue up to 4. How does a commission shall issue up to 4? I'm missing something here.
This is pretty plain reading, Representative Fleming. All right, any other discussion? Chairman Powell. I haven't forgot about you.
I'm thoroughly confused, but that's all right. It's not the first time.
You probably remember that Joe Walsh song, Life of Illusion.
Absolutely. So if I understand that we're replacing, we're going to leave may on line 139, go from may to shall on 140.
Yes, sir.
On 151, are we still going to leave shall at may or go back to may?
We're going to leave out a may on that line.
Leave out a may.
But we're going to change the may to a shall on 152.
All right.
Number 12.
Thank you, Mr. Chairman. I apologize for my confusion. We're making both classes shall. I heard you say shall for the 4, but is it shall for the 7 correct? A requirement? I'd have a question for the author of the bill. If that were true, if we're issuing 15 licenses, do you have any idea on how much production would be in Georgia with those 15 licenses?
I have absolutely no idea.
So what would be the policy rationale to require licenses that we have no idea the production amount that would be in our state regulated?
You know, I think that's just a wild guess, Representative. I'm a firm believer of the free market process. Originally, I know this, I'd said earlier, the original intent 4 years ago was to issue 12 licenses. We knew at that time that based on population statistics about these medical grow operations, that based on Georgia's population, that Georgia should have been somewhere in the neighborhood of 20 grow operations. If that's too many, then the free enterprise system is going to probably put some of them out of business, quite honestly. It's like anything else. If there's an overabundance, then it's not going to go. Or it may create some ingenuity in the medical arts and the cross-hybridization and things like that. They're changing this thing on a daily basis. 4 or 7 years ago when we started into this down this road, at that time it was all about low cannabis. Since that time now, a lot of these these sciences that are exacted, they're blending the low THC, low CDB. So they're saying there's a lot of benefits to this. So that being said, I don't know, but I think the free market as usual will take care of these type of situations.
Okay. I'll call a question on the amendment. Or excuse me. Do I hear a motion on the amendment? Number 5.
I move.
All right. So move. Do I hear a second? Second. Move second. All those in favor of the Smith amendment? Yeah. Shoot, yeah. Go ahead, Representative Fleming. This is Smith amendment, Representative Fleming.
But what is this Smith amendment? That's my question.
On line 140, you're changing the may to a shall. On line 152, you're changing the may to a shall. And then on line 189, right after the period, following the 2023, starting at thee, we will strike all the way down to line 201 to the period.
Can we vote on those separately, Mr. Chairman?
I proposed them together, Representative Fleming. Any further discussion? All right. All those in favor of the Smith amendment say aye. Aye. All those opposed, no. No. Well, that clearly don't pass. All right. No, I can hear pretty good. I've had 5 ear surgeries. I can hear a flea actually. All right. So we're in the posture of passing the whole bill. Do I hear a move?
Hearing no other motion, I move to pass.
Oh, yeah, excuse me. We've already had a move on the whole bill. All right. All those in favor say aye. 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 All those opposed, no? No. All right. Raise your hand if you voted aye. And this is LC number 280592S without any amendments.
6, 7, 7 people for it.
All right. All right. Put your hands down. All those against, raise your hands. Passes 7-5. Congratulations, Mr. Chairman. We'll sign your committee request form for rules and send you back up there.
Well, I thank you. Now maybe somebody can tell me exactly what this does.
Yes, sir. All right. Next up, we have Representative Rick Townsend. House Bill 181.
Let's get my notes together.
Representative Townsend, good to see you again. Go ahead.
Thank you, Chairman Smith. I'm just getting my notes together.
Representative Townsend.
Okay.
Go ahead.
Okay. Basically, we got out of subcommittee. We had a couple of amendments to that.
You had a substitute bill, I think you have in front of you. I think the amendments in there too regarding the word I believe willful. And so anyway, I want to kind of go through the beginning of it and then talk a little about it after that. Or I can hold discussion till the end, Chairman Smith. Basically, if you saw, we took committee input, took public input, and substitute bills does not show a ban as in for the entire product. It still has a Schedule 1 for the elixirs that everybody thought was a bad actor. Everybody in the committee, we talked about it and didn't see it as a good fit. Section 2, it goes over the different levels. I'll go back to that in just a minute. Section 3, it goes into age, moved from age 18 to 21 years of age. It added the comments about or included the vaping, where you couldn't vape, electric cigarettes, things like that. Also, has to be moved behind the counter at a store. That was added as well during the substitute bill. And then Section 4 kind of goes after the bad actors we all talked about. I believe everybody in the committee was agreed we don't need to go after the consumer in that respect, but just the bad actors. The ones aren't labeled and the ones not known what strength they're getting, the concentrate, things like that, whereas the Wild Wild West or Dr. George Lopez of the Georgia Poison Control Center, how he mentioned it was like Russian roulette. If you take this bottle off the shelf, whether it's beside the Reese's or a different shelf or whatever shelf you take it off of, the extract, it's kind of like the Wild Wild West or Russian roulette. So that goes after the bad actors. If it's not labeled correctly, we made sure we changed that language to where the store owner is not will be gone after. No one can go after the store owner if everything's labeled and he sells it as labeled. He's assuming everything is correct. But a manufacturer or distributor who doesn't label it or a store owner doesn't allow it to, it's not labeled correctly, then they'd be in violation of this code as well. I think that was one of the main things I got of the first committee when we first met, talked about let's go after that. And then the input, I believe, is line 84. Council, correct me if I'm wrong. That's what I just mentioned that. A person who knowingly imports, we added the word knowingly there to help out. And that kind of thing helped everybody understand better of where to put it. So that word should have been added as an amendment on the subcommittee. Then you guys, which I appreciate very much, and thankful that you passed out of committee with that one word addition, knowingly. And I believe it was, I can't remember if it was Representative Neal or Kendrick that had that amendment in there. And it was, and you passed, y'all made it, and I agreed with it. I totally agreed with it. It was line 84. It says line D, a person who we added, it says imports.
Chairman Townsend, if you'll suspend for just a minute.
Okay. 84, line D. Okay, I'm sorry. I just want to make sure it was in there because y'all added it.
Brian's going to make sure everybody's got a copy of the right LC number. Members of the committee should now have LC 480881S. Everybody got a copy? Okay. All right. Go ahead, Representative Townsend.
Line 84, line D, and the word knowingly was added. So if you're on the original committee, you didn't know about that addition unless you were present at the time. But the word knowingly was added. Since then, we've done a little more research, talked to actually a local business owner, and there was a couple things that at the end after discussion that I would recommend as well. If you look at lines 18 and 19, and this is just we'd increase the level from 10 to 15 and from 2 to 15 when it talks about milligrams per serving. And then same thing for 28 and 29. It would go from 10 to 15 and 2 to 15. And I mentioned that right before the meeting to Mr. Dow, and he wasn't understood why the increase. And then one more thing I caught that somebody brought to my attention was for line 6 on 71, line 71, 6 in parentheses. It says name and principal mailing address. It really needs to be the name, physical and principal mailing address. So it needs to be the site itself, not just the mailing address. So you know actually know the people who are manufacturing it. And that's it'd be physical and mailing. That was my mistake, and somebody brought it up to me. And I can talk more about the bill, Chairman Smith, or I can wait, or however you want me to approach it. I just want to catch the people who were not in subcommittee at the time about what this bill was. This still allows it. It's not a total ban or anything else. This does allow for use of controlled kratom usage where it is controlled, and going after the bad actors regarding the penalties for the manufacturers, distributors, or sellers who don't do it the right way. And I think everybody in this room was concerned about the labels and making it correctly, but having teeth in the law as well to make sure it is done correctly. I think that was critical, and that's where this bill lies. And just as a comment too, I can go into the people who spoke the first time or the last report you got from Dr. Norton about people who support the original ban, about who supported, who believes in what we're doing with this bill. So I'll be glad to talk more about that too. I'm not sure
In the interest
how much
of time, we got some questions.
Yes, sir.
Number 16. Representative Byrd.
Thank you, Mr. Chairman. Would you please clarify for me, because I thought I heard you say that a store owner will be responsible to check the label when it comes in the store, and if it is not correct, he would then be charged? Is that what I
If they
understand?
sell it, they have to know what they're selling to the public, and you can't sell the wrong product to the public, the illegal products to the public. If it's mislabeled, that's not on the store owner at all. That's not their fault. If it's labeled, if it's not labeled at all, like you'll see the samples right now in the stores, it's not labeled at all, and they try to sell that still, that's who it's going after.
I just want to make sure that the store owner would not be held responsible for reading every label and making sure that it is in fact correct. I guess the part that you're saying it now has to be labeled, but is the store owner supposed to go through every bottle or whatever it is going to be sold?
Well, shipment, you've got the receipts and everything else. You've got if it's in a shipment, it's going to all be alike. You got to know what you're selling. It's just like when I equate it to buying beer or alcohol. The store owner knows what the label is supposed to look like when you buy a beer or alcohol. Other than that, they sell it. They assume that product's good because that's what the label says. And that's all we're doing to do is trying to mimic that. So it gives that person the right to buy it if they want. It won't be buyer beware. It'll be consumer oriented at least.
Chairman Leverett.
Thank you, Mr. Chairman. To Representative Byrd's question, my understanding is the addition of the word knowingly was so that we already had provided that the the person selling was responsible for at least verifying the exterior labeling of the product, we were concerned they might know that the contents could be improperly labeled, in the sense that it has a good looking, correct, compliant label, but the thing on the inside is over the required concentrations. So we're not making the shop owner liable in that situation, but he is liable if he or she is selling something that is not properly labeled in accordance with the statute. If that
Correct.
addresses, which I think is customarily the scope of their criminal and civil liability now anyway, for someone reselling a product.
And that's why another recommend the knowingly. I wholeheartedly agree with that. That helped.
That was the Kendrick Amendment. I remember it well.
Thank you. I thought I was representing Kendrick, just making sure.
And number 13, Representative Gill.
Yeah, it's me, sorry. So you said that, whenever they bring alcohol in there, I don't know how Kratom's sold or how it's delivered to the stores it's sold, but alcohol, for instance, is usually brought in by the manufacturer. They stock the beer area. Same with the potato chips. Potato chip, Hanover or whoever, Lay's comes in there and they stock the potato chips. I don't know that the store owner actually knows it is properly labeled on potato chips or alcohol today. So I don't know how Kratom. I'm not sure if they have I think alcohol has to have a separate arm in selling it as part of our law, but potato chips obviously don't. Probably candy bars don't. So is that how is a convenience store? How do I get this Kratom that I'm selling? Is it shipped to me in a box and I put it on the shelf, or does someone else come and stock the shelves?
From what I understand, the regulations aren't there yet, and that's where it's buyer beware what you're getting.
No, I understand that, and I support your bill. So this is a friendly question, but I do want to know the answer. So how does someone, if I own a convenience store, how do I receive the product to put it on the shelf? Does someone, like for potato chips and for the Hershey bars and stuff, someone actually comes into my store and stocks and actually puts that on the shelves? Generally speaking, I'm not sure how Kratom does.
Yeah, can I defer that question to a business owner here that sells it?
Sure. I mean, that's fine.
She'll tell you exactly how she gets it. This is, Mr. Chair, if that's okay. Yeah. This is.
Although I am limiting testimony to 3 minutes in the interest of time, I've still got a subcommittee that's got to finish up.
Okay, if you just introduce yourself for me, explain the process. Yeah.
Hello, I'm Angie, and I own a Kratom bottling business, and this is actually the product here. And I am a vendor. I am approved by Department of Agriculture to sell this product.
Ma'am, if you could get a little closer to the microphone for
sorry.
us.
And that allows me to bring the Kratom to health food stores. So this currently is being sold at 2 different health food stores here in Atlanta. But I think your question was, how do people bring other products in?
Right, yeah, for like potato chips, the potato chip guy goes and stocks the shelf and takes off the old ones and puts the new ones on, and the candy bars and the Coke and all that stuff is usually not the actual clerks at the store who does it.
Yeah, so that's going to be a vendor, a Kratom vendor. Now, whether they're approved to sell Kratom is a different story, right? But like for me, I am approved to sell in the state of Georgia. I can actually ship my product as well. Based on how my licensing shows through Department of Agriculture. So those other people are bringing in their product by using a different vendor.
Okay, and so who stocks the shelf? Do you stock the shelf, or does the person?
I do not. I just bring the product in, and then the person will put it up on the shelf.
Okay.
When I bring
and that's
it in.
common amongst your industry, not just you?
Just me. I'm probably the only person in the whole U.S. It's actually approved to sell Kratom through Department of Ag.
So we don't really know the answer.
Mm-mm.
Okay.
Number 12, Chairman Sings.
Thank you, Mr. Chairman. Representative Townsend, I can probably answer this first part of my question myself, but I'll go ahead and ask you: are you aware of anyone that's that has OD'd for overconsumption of potato chips? From personal experience, I can agree with you. Would you agree that if store owners are not taking a direct approach to putting this merchandise on their shelf, that though there may be benefits to this product, that if this bill changes that and they have a direct, more oversight on what's on their store shelves in this regard, that would be a positive for Georgians.
I think definitely be a positive, good for the consumer.
Thank you.
Number 4, is that Representative Miller?
That is. Thank you, Mr. Chairman. Hi, Rep. Townsend. Just a couple questions. Thank you. I know you've been working hard on this bill.
ma'am.
I was not present for the full subcommittee hearing, so I just want to understand the Schedule 1 aspect of your bill. You have specific amounts listed in, I guess it starts at line 18, where we say, you know, we had 10 milligrams per serving size, and you just switched that to 15. Can you just explain to me where these numbers come from?
We pulled the numbers from a journal. I gave the name last time. I can look it up again. The journal's name, Journal of Science, of the chemistry of the leaves itself. When the powder is associated with the leaves, you can make the mixture there. And then the new numbers where it increased from 10 to 15 and 2 to 15. It actually came on after talking with their store owner and looking at the recommendations from that distributor and looking at what's being sold right now in a safe manner. That's why we increased the numbers. The original research came from the journal. I can get you that journal too. If you want to give me a second, I can. The exact name and come out of the article. And then the rest of it was based on input we got from a local business owner.
Okay. And so so does your bill criminalize possession of an amount that contains more than 15 milligrams per serving to the tune of 1 to 15 years in prison?
No, if everything's sold correctly, no. If you're buying it off the shelves, if this bill passes and becomes law, and you're buying the approved amounts, you're fine. You can buy multiple doses, that's fine, but it's the concentrated doses sold at once in there. This is based on the research. This is getting down to the level of the leaves, like we talked about before. The chemistry of the leaves itself, the plant-based product.
Okay. And so there is no corresponding criminal provision for, sentencing provision for your amendment to Schedule 1 in Georgia. Is that
For
is that
consumers
accurate?
you're talking about?
I'm saying, so if we have made kratom a Schedule 1 narcotic, is there a criminal penalty that goes along with possessing it, like if you possess heroin, for example?
The elixirs would be, yes. The elixirs we're talking about, that's what's Schedule 1 in here right now. Those little bottles that we talked about, you buy off the shelf, the concentrate, the one that's very inaccurate right now, that is, it doesn't make extracts like that. Schedule 1.
What would be the penalty, though, for, say, I guess I'm just trying to find out if there is a corresponding criminal penalty connected to us putting this in the code as a Schedule 1 narcotic.
For the extracts, and I think we all agreed the first meeting we had, the original committee meeting, was that if nothing else, get rid of those extracts. That seems to be the bad player. We heard from all the witnesses, the parent, the moms, the wife, and stuff like that, people like that. But that is the one exception to the Schedule 1, as in those. This would eliminate those elixirs, I guess, if you want to call it. This wouldn't eliminate kratom. And this wouldn't eliminate your store owners and the one who just testified to clarify a point, plus the one up in Rome that testified that day. Wouldn't eliminate them from selling it, but it would keep those elixirs or extracts, however you want to call it, a Schedule 1.
Okay. And is the criminal penalty for that then
it is a felony.
1 to 15?
Yeah.
Is it 1 to 15 years?
For the extracts, yes, it would be the felony. That's the part that we kept, and that was based on input from this committee to keep that part in there, because that's the information we got regarding the bad actors. That's not the. I think everybody agreed, or most people agreed at the time, that was not a good product, and that needed to stay the same because we're not sure what you're getting when they start mixing that.
Okay.
Those little liquids.
Okay. Thank you.
Number 11.
Thank you, Mr. Chair. Representative Townsend, during the subcommittee meeting, I think I pointed out line 88 through 90, and I had asked who that section would apply to, and I believe you had stated possibly we need to take that out unless you
Yes,
found
no,
an
we can
answer
do
to
that.
my question.
Yeah, I don't think it was amended at the time, but you
Okay.
did say that, and I did agree. I think that could be taken out. I actually have got a line through it on my notes.
Okay.
I was going to mention that at the end too. It's lines 88 through 90. It was discussed to take that out, and I agreed to it at the time, but an amendment wasn't made at the time. And so that could definitely be an amendment.
Thank you.
Maybe to help things move along, here's what I'm going to propose. Make the fixes and bring a sub back to us so we're able to look at the whole thing on Wednesday.
Okay.
We'll hear you again on Wednesday. Anybody signed up to testify to this, I would suggest that we wait until we have that sub with the changes that were proposed here. If you want to speak today on this current version, you can. Just know we're going to have some more language taken away and added to. You want to speak? Yes, sir. Yep, I'll give you 5 minutes. And good to have you with us again, by the way. I know you were here for a while with us before. Just introduce yourself for the committee.
Thank you, Mr. Chairman. My name is Mac Haddo. I'm the Senior Fellow on Public Policy with the American Kratom Association. I think you'll remember Joe Walsh's song, Walk Away. We would recommend that this needs to go to study. There are more red flags today after hearing a re-description of this proposed legislation that contradicts good science. And in fact, the question I think that the committee should ask is, if all the things that you've heard were true, why isn't kratom scheduled at the federal level? Because they look for this very kind of evidence. Are there overdose deaths? Is there an addiction liability? Those are the key questions. And in 2016, the Drug Enforcement Administration rejected the FDA's recommendation, said insufficient evidence. In 2018, HHS rejected it, called it embarrassingly poor evidence and data, and yet that's what you're relying upon today for this bill. And in 2021, the Expert Committee on Drug Dependence at the United Nations Drug Control Policy Board unanimously voted, 12 independent experts, that there was insufficient evidence to ban kratom, because kratom is helping people. Responsibly used, properly regulated kratom is actually helping people, and that's the evidence from Johns Hopkins University, not funded by AKA. You have evidence before you, and the binders were provided of multiple studies, and there are actually more than 100 new studies since 2018. The fact of the matter is that the levels of the serving size identified in this bill are drawn from thin air. There's not a bit of science behind them. And we can show you multiple studies that talk about the presence, depending on the maturity of the plant, as to how many milligrams per milliliter are in the kratom plant. You cannot base it on this kind of evidence. It needs to be done based on pure science and the safety factor of kratom itself. 7-hydroxymetrogenine is a potent metabolite, not an alkaloid, a metabolite that comes from the drying process of the plant. It never occurs in natural form greater than 1%. Anything above 1% should be banned because then it's been tinkered with. We agree with that. This needs to be studied so that everyone understands the same scientific platform that we're working on. Legislatures should be sanctuaries for pure public policy, not supporting some level created by some attorneys that are prosecuting a case. Let them do that in the courts based on the evidence. Don't let them take this legislature, become a pawn, and go down and say, look, the Georgia legislature agrees with us. This level, even though there's no science behind it, is dangerous. That's what we should guard against, I think, as legislators. This does criminalize retailers and processors. Have you ever heard of a recall? Ever heard of counterfeiting? Under this legislation, they will be held liable. You could make a simple mistake in the production of your product subject to a recall, and you're guilty of a felony under this statute. It needs to be studied and refined much better than it is right now. None of the information that you've heard, and you look at the 6 states who banned kratom, you heard that in the subcommittee hearing, true, all between 2012 and 2017. 3 of those states are taking action to remove the bans. Rhode Island, the Director of Public Health has already said it doesn't meet the criteria. Same in Wisconsin, the Controlled Substance Board said that 6 of the 8 criteria are not met. In Indiana, the House passed a repeal of the ban last week, 53 to 40, it's now gone to the Senate. People are looking at the science today, and I would hope the Georgia legislature does that as well. The Mayo Clinic, the Cleveland Clinic, and WebMD, those are cited frequently. Not one of them has done an independent study on kratom, not one. You won't find any literature, ever. What they do is repeat what the FDA says. I understand that. WebMD last week, or 2 weeks ago, came out with this statement. People have died after taking a commercial form of kratom that were laced with hydrocodone or morphine. The leaves by themselves are not linked to deadly overdoses. That's true. That's the science. And yet we're acting here today as though there are overdose deaths related to pure kratom, and that's not scientifically justified. So, Mr. Chairman, I would urge this committee, look at this for study. We will work cooperatively with Representative Townsend. I've told him this. We can find the right place for this regulation to allow kratom consumers to responsibly use it, and you will save lives. And I would ask you to listen to Dr. Joie, then the Assistant Secretary for Health, when he said if you ban kratom, you put millions of Americans at risk of death because you force them off of kratom, where they're managing their pain, managing their addictions, and you put them back into a more dangerous product. That's the bottom line. So, Mr. Chairman, I'm glad to answer any questions. We urge this committee to go to a study here, and let's research this further.
You did that with 12 seconds left. Good job. Vice Chairman Silcock.
Thank you so much for coming back today. I appreciate your testimony, but I wanted to ask you, isn't it true that we had testimony that this is an addictive product?
It's a benign addiction similar to caffeine. The testimony that you heard, and it is true, you can become dependent on kratom. It is not the same addiction profile as an opioid addiction. Vastly different. It comes from the coffee family plant. It's similar to caffeine, and that's
But didn't we also have testimony that people died purely just from taking the kratom?
Incorrect statements, not based on science, and that's why it's not banned federally. That's why the director of the Office of the National Institute on Drug Abuse says the kratom should be available as a harm reduction tool. It's not killing people. Even the FDA admits now that it's adulterated kratom products that are killing people. It's not pure kratom. They admit it, and you're relying on old testimony or old evidence that was called embarrassing poor evidence and data. Nothing links to pure kratom being the cause of any death so far.
Even though we had testimony to the contrary.
The testimony was incorrect. The science is clear. It is clear.
If people died from the kratom and that was found to be the cause of death, then that's pretty clear. That's how they died.
Ma'am, with respect, what you heard from Dr. Eustace, she has looked at every single death reported and the autopsies associated with it. None were related to pure kratom alone. Always adulterated products, underlying health conditions, or a mixture of other products that the person was taking at the time. That was the evidence that is current science.
So do you think it's good to go from one addictive substance to another one?
Don't have to listen to me. You listen to Dr. McCurdy and Dr. Volko. They say yes, a less addictive substance as a harm reduction tool that doesn't cause respiratory suppression and kill you, yes. You trade, and that's what, by the way, what we do with the addiction profiles now. FDA-approved drugs trade the bad opioid for Suboxone and methadone. They're highly addictive. They're scheduled, so yes.
Well, I will say this, that my husband's a physician, and he's the first to testify that 20 years ago, we used to give people cocaine to get off of opioids. So I just don't know that we have enough science to really determine what you're saying is true.
Well, ma'am, I understand. And I think that if you looked at the current science today, that would contradict your conclusion. Mm-hmm. But I agree, we need more information, which is why I encourage the study committee to hear all of this so you would have the benefit of hearing the range of scientists.
Isn't it true that the concentrated kratom is more dangerous than the pill form or the powdered form?
Well, this is, again, if I may, that's another misnomer. We talk about extracts. Mm-hmm. Extracts are both elixirs, mm-hmm. which you saw one, mm-hmm. and powders. You extract powders too. Representative Townsend, again, you need to study this. He doesn't understand, or the drafters didn't understand, you can have a powdered extract. which is dangerous. I agree. So it has to be extracted with the right FDA-approved food-grade extraction methods. Then it's okay. It's like you go to Starbucks.
But this
and
is
you buy
approved by
latte.
the FDA, correct?
The
This is not approved by maybe the extract standards, but not Kratom, correct?
Kratom is not approved by the FDA for a medical use. Neither are 20 or 30,000 dietary supplements that are
Okay,
still on
that's
the
true.
market.
That's true.
Yeah.
Thank you.
All right. Number 12, Chairman Saines.
Thank you, Mr. Chairman. Could you tell me, is there a level of kratom that you feel someone could take and have a harm effect from?
I suspect that there is. We haven't found it yet.
So you could not tell. Could you tell me what is that you would be assured that it was that there would be no harm effect that would happen from an individual consumption? Can you give me a number? You're upset with the number we decided on this bill?
That was a made-up number that no one can justify. And so I think the right approach to this would be that you look at the science, which shows that of the naturally occurring alkaloids in the kratom plant, were then allowed to be either produced into a finished product or an extract using FDA-approved extraction methods, which limits the power of the alkaloids. Those are safe products.
Is it not true that we've had a study committee on this 5 years ago and that the industry hasn't taken any actions to change items from that study committee, and this is a legislative response to that inaction?
So I don't represent the vendors. My understanding, because I was involved in helping to get the 2019 bill passed, that was a direct response of the information that had been gathered by the legislature. So yes, there was action taken in 2019. Didn't go as far as we would have liked it. That was a modified Kratom Consumer Protection Act, which lacked the enforcement mechanisms which we advocate for. Not these onerous one that criminalizes potentially over 200,000 Georgians who are using Kratom today. And certainly we don't support the idea that you would take an error that's made by some vendor that has a mistake in the processing to be subject to a felony. That's why we have recalls. We recall the product, and there are plenty of opportunities for someone to recover damages if they were injured by a poorly processed, mistakenly processed product.
Thank you.
Number 17, Chairman Leverett.
Thank you, Mr. Chairman. Good afternoon. Just responding to your testimony, my understanding of the bill was it is not rendering all kratom illegal. It's only kratom in excess of certain concentrations.
Well, actually,
Yeah, that was a question for you to respond to. Yes.
Okay, so if you look at the specific limits that says they banned kratom product above a serving size, and then they modified that in the current version. They upped it a little bit. I checked with the original version. There isn't even a test sensitive enough to get to the 0.5 thousandths of milligrams per gram of 7-OH. Not even a test. So even by boosting it, I don't think you're going to find that you can even test for it. And if you can't test for it, then how can you possibly verify whether the product is actually compliant with the product levels? That's why if you take the natural plant levels and you restrict the extraction methods to only FDA-approved food solvents, then you can produce a safe product. This is they've arbitrarily drawn this number, and I would suggest it's for one reason. They want to go down to the court in the cases they're prosecuting, and they want to tell the judge, even the legislature agrees that look at the level this guy had, and look at what they said was safe. They can't back that up with science, but they'll use you, meaning the legislature, to be their validator. And you're not going to be able to say that you had any science to back it up either, because none of the science documents that.
Well, I thought we had some testimony that there is science to support the naturally occurring levels of kratom in the leaf plant.
I would be glad to share, and that's why a study committee would be great, because this is a very important issue. Dr. Chris McCurdy, along with some associates, he's the leading scientist funded by NIDA, not by us. We've only funded one study. NIDA says that depending on the maturity level of the tree and of the plant material, how long it's grown, whether it's early harvested, the ranges will vary dramatically. But at the highest level, fully mature plant material that's allowed then to be processed into powder and shipped to the United States for finished products is not harmful. It's not. And it's well above these levels, well above And I'll be glad to share that article with you.
So is that, you had mentioned, I think in your testimony, some concern about adulterated kratom products. You acknowledge that's a problem.
Not only do we acknowledge it's a problem, Secretary Becerra, in a letter that was sent to Senator Mike Lee of Utah and Congressman Pocan, said that, not the FDA line, that he said adulterated products are the cause of the deaths that are going on, and underlying health conditions and poly drug use. Those are the problems. But adulterated products are horrible, and we need to fix them. And you do that with good labeling. You do that with what we would recommend. You go to the Department of Agriculture. This is the model Utah uses. You register every product, and you force the manufacturer to give you a certificate of analysis that says it complies with your law. And if they then catch them later, then you penalize them. And they lose their registration. They can't sell in the state, and you can fine them. Penalizing with a felony conviction doesn't really work in the sense that you'd think it would. The way to manage this is to have good standards using the Department of Agriculture to regulate it, not this. This is a horrible bill when it comes to protecting consumers. We want, and by the way, the director of the Department of Agriculture in Utah has said that that bill has worked. It's been in place since 2019. They charge every vendor a fee, and then they finance all of the regulatory actions from that, and it works. It protects consumers.
One other question, Mr. Chairman, if I may. My understanding, though, is the remaining sections of the bill after Section 2 address the issue of labeling and prohibiting adulteration. I'm just curious why is it primarily just the scheduling of the kratom based on concentrations you contend are not scientifically based that causes the objection, or is the rest of the bill objectionable to you as well?
Well, I think that you could look at this bill and say, okay, it's just full of penalties, but it's not full of a regulatory framework and structure that will protect consumers on an ongoing basis and make sure that if you had a complaint, if you had an adverse event, you send that to the FDA. We would recommend that gets sent to your Department of Agriculture too. They open up an investigation, force the vendor to submit a new certificate of analysis from an independent third-party lab showing compliance, and if they can't produce it, you destroy their product and remove them from registration. That will clean up the marketplace because it's not worth it to these vendors. That's what the Ag Department Director of Utah told me. We don't get bad actors because they don't want to come here because they know they're going to get stuck with us regulating them.
So you contend that creating a felony for selling a substance that is in excess of permitted concentrations is not sound, is not a sound manner of preventing that activity.
I would respond this way. I think that a felony conviction for anyone that puts a controlled substance into a kratom product, that's already there, but they should get it. They should be fully prosecuted. If they stick morphine, codeine, heroin, fentanyl, that's the one prop of choice, just to give it a boost it doesn't have, they should be prosecuted, but they already will be if you identify it. Should a manufacturer be prosecuted because they're 2 milliliters above or milligrams above what's in the standard because they had some mistake in their process? That's horrible. And I don't think that should be done, but that's what this bill says, and that's what I think is a poorly formulated regulatory system. We can do better than that.
But if someone intentionally were to do that, it would be an appropriate penalty, wouldn't it not?
Well, if you intentionally increase the levels of metrogenine, for example, in the product, if you intentionally did it and it's in violation of the criteria, then I think that's probably a misdemeanor kind of thing because it didn't hurt anybody. Felonies is to protect someone from getting killed, and there's no evidence that that level produces any safety level at all. So I guess that would be my opinion.
Okay. All right. Thank you.
All right, thank you. To my friends over to the left, write your questions down. We'll ask those on Wednesday. Thank you, sir.
Okay.
Thank you for being with us.
Did you
All right.
recognize the song?
Which one? Oh, yeah. Oh, yeah,
Walk
yeah.
Away?
I love Joe Walsh. Yeah.
Okay.
Yeah. Ever since he
Thank
got
you very
straight and got off drugs. I was thinking of a Jimmy Buffett song, Manana, but I won't repeat the line I was thinking about. All right. That's all we have for full. We're going to adjourn, take a 5-minute break, and go back into Leverett Subcommittee. Thank you.
Why don't we go ahead and get started back up? Representative Hilton, why don't you come forward and present House Bill 219 to us again? When you're ready.
Yes, sir. Thank you, Mr. Chairman, members of the committee. I am here to present to you House Bill 219. I'm reading from LC 48089-1S. The problem we're attempting to address here is one that all of us have either faced ourselves or through a family, friend, or relative, and that's the common financial crime now that unfortunately we see so rampant in our communities is you click a bad link, you visit a bad site, and all of a sudden your money is taken out of your account and placed into someone else's account. The issue that we're facing right now is a problem of prosecution. That money is elsewhere, and according to the current statute, we have to refer that case out and into a different jurisdiction. And so this bill attempts to address that issue. I'm grateful for the committee and its work. We spent a lot of time following our conversation. 2 pieces of feedback. Number one, the bill's too long, too many words. We've shortened it significantly, lined it up with the right statute. We found some case law, and we've met with both the prosecuting attorneys council and the Georgia Defense folks, and everyone is kumbaya on the same board and kind of blessed and sign off on the bill. So here to present it to you today, I've got Will, my trusty sidekick from PAC, with me. Run through real quick. Section 1 deals with specifically with money laundering, and I'll point your attention to lines kind of 19 to 22. When money laundering occurs, it gives kind of 3 places where you can proceed with prosecution. Again, if it's exercise control in a certain county, any county where the act was performed, or in the county of alleged victim. Section 2 deals specifically with the act of theft, and I'll direct your eyes to lines 36 and 38 there, and the county where the act was performed and or where the victim resides. So that's the bill there. Will, you're happy to add any comments? And I'll
very quickly, I will say this is limited to electronic or digital money or currency. It will not affect current hard currency or anything like a lawnmower if it's stolen. It's limited only to those where it would be difficult with digital forms and electronic forms of money. I do appreciate the work Jill and Gachtel has put into revising and coming to a consensus with us. We did discover there are 2 cases, the Naylor case and Davis v. State, that both say this is actual real harm, where we cannot prosecute these cases in Georgia, where we don't have the proper venue. So we found real harm, and we have come, I think we are in agreement on the language, and I appreciate her work on that. I believe there are 2
I do
quick
want to,
changes.
at the appropriate time, they've recommended 2 minor additional changes. On line 16 is where it can be found, where it reads such money or currency. You would delete that and insert the monies, and that's meant to align with definitions spelled out further in Chapter 1, Title 7. So you'd replace such money or currency with the monies, and then further on, involved in, cross out such and put a currency transaction. And that would be and that again just lines up with the proper definitions.
Is that the only proposed amendment?
Yes, sir. Yeah.
All right. So just to make sure I can sort of bottom line it, we're deleting some of the language which seemed to scare people, that I think was basically just intended to establish a jurisdictional nexus and state interest, but that's taken out. And some of the other options for venue, I think they've been pared down to the options that are left in the substitute.
Yes, sir.
Is that a fair statement? Okay.
Yes, sir.
All right, and so to repeat the amendment, just so we know what we're talking about, is to, on line 16, delete such money or currency and replace it with the monies, as in give me all the monies, and then delete the word such and replace it with a currency.
Correct.
Okay.
Yep.
All right. Any questions for the sponsor or for Will? I don't see any questions. All right. Do I have a motion?
Motion.
Well, hold on. All right. You make a motion to pass. Representative Reed seconded. I have a motion second. Any discussion? All right. What's that? All right, so I've got a motion to amend, as we discussed earlier. That is to replace such money or currency with the monies on line 16 and replace such with a currency on line 16. So I've got a motion to amend in that way. Do I have a second? A second. I have a motion and a second. Any discussion? All right, all in favor of the amendment, signify by saying aye. 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 All opposed, like sign. All right, so we've got an amendment. Now we have the motion to recommend due pass to the full committee of this bill as amended. Any further discussion? Hearing none. All those in favor say aye. Aye. All those opposed, like sign. All right. So we've now recommended your bill to full committee.
Great. Thank you, Mr. Chairman. Thank you, committee.
Thank you.
Thank you.
And Jill, you had signed up, but I gathered your nodding in the back was all the testimony you wish to give? Or did you, okay.
So, just to acknowledge the chairman and moving this through, and just for purposes of whoever's writing the amendment, it's MONEYS.
Oh, thank you.
It's a defined term instead of MONEYS.
Well, thank you. I had already messed that up.
Welcome to Georgia.
The monies.
All right. Thank you. All right. All right. Now I believe we've got House Bill 383. Vice Chairman Reeves. And I think we're working off of LC 4913. Is it 1375?
They should both be in there, but the other one should be in there as well, though, because we've got a late one.
Yes, 1375S is the substitute. You may have another one in your
I'll
packet.
swap.
Did you find that, Chairman? Okay, we can share. All right, please proceed.
Good afternoon, Mr. Chairman and members of the committee. I present to you the Safer Hospitals Act, House Bill 383. The current LC number is 491375S. The outdated one is 491362S. 62S was last week. 1375S is current as of today after some work over the weekend. The Safer Hospitals Act, I want to thank the Majority Leader, Chuck F. Strachan, my friend from Gwinnett County, for starting this effort at the request of Piedmont Hospital. Piedmont Hospital is a nonprofit hospital headquartered in Fulton County but with campuses around Metro Atlanta. So the original version of the bill, one of the reasons for the substitutes was to change the population and the scope to a broader one, because after this bill was filed, we had a number of different hospitals, some of whom are represented here today from small town Georgia and who did not fall under that original scope. So we had a request for a broader scope and we made it to the bill, so this would apply to a variety of hospitals. But this bill has two main components. The first is it would explicitly allow hospitals, just like college campuses, to form a hospital campus police department with post-certified officers who are full-fledged law enforcement officers who would know how to get from the front door to every nook and cranny within that hospital and would know about the specialized issues going on in the hospital and be able to respond quicker and with more knowledge than, for example, in my area, the Gwinnett Police or Lawrenceville Police or Duluth Police might, if they're called into the hospital. You would have more specialized and knowledgeable officers there on the hospital campus. Secondly, it does provide for an increased penalties when someone assaults a healthcare worker on a hospital campus. Right now, and this is precedented, you have battery against peace officers, transit workers, teachers, first responders, various vulnerable populations. And if you think about a hospital campus, you've got a lot of healthcare workers who are, in the zone trying to get from point A to point B and treat patients who are in life-threatening emergencies and with people's life and health in the balance, and you want to have them safe and secure. We're going to hear some testimony from some healthcare providers on the need, the increased need to include hospital workers in the protection of the law that we have for several other categories of vulnerable population, and we have a minimum going from 1 year up to 3 years on assaulting healthcare workers. It's 1 year in general on assault and battery. That would go up to a minimum of 3 years. So those are some of the high points of the bill, but I would like to thank, again, Piedmont Hospital as well as several other hospitals who have weighed in. We have representatives of nurses. We have the Georgia Chamber, and I believe Katie is here now. Thank you for coming in person as well as sending a letter ahead of time. Health care is at the top of their list of needs in Georgia, and I appreciate them looking over this bill and supporting it. Georgia sheriffs reviewed this bill, and they are one of the ones who gave input and helped us improve the bill from when it was originally filed. I would also like to thank Jill Travis. I want to make clear, Georgia Association of Criminal Defense Lawyers, they're not going to sign off on the bill, but Ms. Travis helped bring to bear her years of experience in improving the language of the bill, even if we do have a public policy divergence on the scope of the bill on some technical issue. She helped with some technical issues in improving this LC number that is before you. I wish some of the prosecutors had not cleared out so quickly and got to hear about this bill in hopes that it would pass to give them another tool to keep our hospitals and healthcare workers safe. I believe the need for this bill arose before COVID, but definitely with the disruption that's happened in healthcare over the last 3 years, certainly that makes the need to have safe and secure hospitals all the more important. Somebody mentioned Mother Teresa earlier, about how Mother Teresa wouldn't be represented in a certain industry earlier. Well, literally, if this bill applied in India, she would be protected under this bill. So we got people who are delivering health care who, we all look up to and our lives depend on it. And let's protect them through this act, and it'll help with recruitment and retention of healthcare workers, as well as help close the gap on some of those shortages in healthcare workers here in Georgia. We want to make Georgia attractive for nurses and other hospital employees to come and work long term. With that, I am going to turn it over to Lavinia to introduce one of our witnesses, Mr. Chair. Thank you.
All right.
Lavinia
That's
Luca.
fine. Why don't we hold the questions till we've heard from at least
Lavinia
the
Luna from
witnesses.
Piedmont Hospital.
Okay.
Good afternoon, Lavinia Luca, Executive Director of Regulatory Affairs with Piedmont Healthcare. Here with me today is Mike Hodges, our System Director of Public Safety, to speak in favor of the bill. Thank you.
Good evening. So, Mr. Chairman, members of the committee, I really do appreciate the time today. When I was asked to come and speak in favor of this bill, I was asked to tell a story about workplace violence. And I can tell you several stories about workplace violence in healthcare. I can tell you about a nurse who was stabbed with her own pencil after she was assaulted by one of her patients. I can tell you about a patient care tech who was sexually assaulted by the patient that she was trying to care for. I can tell you about a physician who was beaten over his back with a small end table that was picked up by an angry man who had received some sad news. Each of these stories matter, but unfortunately they're not isolated events. They are representative of thousands of stories that play out like those each and every day in our healthcare systems. And each of them matter very specifically. Healthcare is today the most violent industry in the United States. Nurses and other patient care staff are more likely to be assaulted at work than any other professional group, and that includes police officers and corrections officials. The workers that serve our most vulnerable populations and patients are under siege, and they live in perpetual fear of the people that they serve more often than not. And this is a reality for healthcare workers even in the midst of all the stressors that they've endured over the last couple of years. Verbal assaults such as harassment, intimidation, threats, derogatory and racist language, as well as the physical abuse ranging from simple battery to sexual assault to murder. Healthcare workers are 5 times more likely than any other group to experience these in their daily work. And it isn't just affecting our workforce. Violence in healthcare is also affecting our patients. An American College of Emergency Physicians has recently noted that 80% of physicians acknowledge that violence has taken a toll on patient care, and 50% of the physicians surveyed acknowledge that patients have been directly harmed by violence in this setting. Is it any wonder that under these conditions we lost 200,000 employees or workers last year? The healthcare workforce is under crisis, and even in the most recent Georgia Healthcare Workforce Commission report cites that workplace violence is one of the key drivers of workforce attrition in healthcare. And unfortunately, our organization, Piedmont, is not immune to that. In the last 2 years, we've seen increases in every area. Our average number of workplace violence incidents reported by our employees has increased 99% in 2 years. We now average 80 events per month. In the worker compensation claims due to workplace violence injuries has increased 83%. Requests for assistance from our security forces has increased 114%. Our officers are requested to support medical staff 640 times per month on average. Each of those numbers relates to one of those specific stories. To stem this tide, we have to do something. We have to take action. And first, we have to start by holding violent offenders accountable. And second, we have to start giving access and equipping hospitals with every available tool to combat violence. Based on my experience and expertise, I think this act is a bold step in the right direction. It provides tougher penalties for violence against healthcare workers, and it gives hospitals direct access to law enforcement tools, which can help us fight this fight. Specifically, the capacity and the ability to directly train and equip hospital security teams with law enforcement officers, the ability to access all levels of Georgia Post training, will be an amazing opportunity for hospital security teams to enhance their protection of this critical infrastructure. This legislation would bring Georgia into a larger movement across the country as to address violence against healthcare workers, as 29 other states have already done this very same thing. Safer hospitals make sense for everyone. They make sense for our workforce. They make sense for every Georgian who is seeking care in any of those facilities. And no one should have to endure the kind of violence that we see in healthcare every day. I ask you to move this forward. Thank you.
Thank you, sir. Any questions for this witness? I think we have one.
Yeah, thank you. And maybe you don't know the answer. Maybe the author of the bill does. Do we give the ability to create a police department to any other nonprofit in the state? I know we do it for, colleges, like government entities, obviously. Are there other nonprofits, even like the World Congress Center, which I guess is really more like an agency of the state, but about a nonprofit?
Definitely colleges. We voted last week on HBCUs in Atlanta being able to consolidate their police departments.
And they're private colleges?
Private nonprofit colleges. Of course, public colleges do that. Georgia.
Yeah, I think of that as a government entity, though,
Right.
so government related.
Government.
Yeah.
Railroads have a very similar situation. So they're a private entity that has the police power under Georgia law. Those were the two that I identified with Legislative Council. And then, of course, the Ports Authority. We had that bill.
Mhm.
They're quasi
Government entity, though, yeah.
Right.
Yeah. Okay. Thanks.
You bet.
Thank you, Representative Gullett. Let's see, did I get you cut on? Yes, I did. Please proceed.
Thank you, Mr. Chairman. I just want to thank you for bringing the bill. My husband's a physician with Piedmont Clinic, and so appreciate Piedmont and all that you do. I will say that he has been held up. He has been threatened by patients almost to the point of violence in clinic, and has to routinely have another healthcare worker be a witness in the clinic. And so, and with the workforce challenges we have in healthcare, as you mentioned, because so many people are retiring and that sort of thing, I think this is critically needed. Thank you.
Thank you.
Thank you, Chairman Silcox. Representative Neal?
I was trying to make the motion.
Oh, okay. All right. Is it Representative Fleming?
Yes.
Okay, sorry.
It's unfortunate, but thank you, because we have to head in this direction. But I was thinking about the story you talked about, the man who got bad information, and he kind of, sounds like to me, he kind of went crazy for a minute. And, you can't hit anybody when you get bad news, but we all know that people that receive something very traumatic sometimes lose their senses for a while. And I'm just trying to distinguish what happens now in that situation and what will happen under this bill in that situation.
I could speak to that a little bit. I was enthusiastic about this bill because I remember campus police in college. There was a list of 10 or 15 or 20 things that they know that they are used to dealing with in either interdicting or de-escalating differently than Macon police would have done down at Mercer. So, college campus is knowledgeable. We already have, some hospitals have security if they're public. And some of them have security guards, so they're kind of halfway there. But having a list of trained and experienced post-certified officers who know the top 20, 15, 10 things that go wrong in a hospital in terms of safety issues, whether it's the parking deck and muggings or car break-ins, or whether it's areas of the hospital where people are healthcare workers are vulnerable, I think is something that will be good. And also, you look at where these are, Atlanta and other big cities with a lot of traffic and all that. It's going to free up the police to go deal with other crimes. It's just a win-win type situation.
Thank you.
And I'm glad to hear, Representative Reeves, that you apparently were on a first-name basis with all your campus police. So
I was at a small school.
So was I, and I'll just say
a long time ago.
It seemed like a really good idea at the time. That's all I have to say about that. Representative Neal?
Yes, I did have a quick question. I know a lot of the violence tends to come from some mental health patients. Does this bill account for some of that as far as, I guess, I won't say discretion, but for lack of a better term, discretion?
I think the good things that the Georgia House did last year with mental health and the things that are being done right now will help, but we intentionally stayed out of having details about mental health in this bill. Okay. But certainly the general landscape of mental health and law enforcement and post-certified officers will help this situation.
Well, follow up.
Yes, ma'am.
I say that because I know that some departments have shifted to a model where they have mental health operatives respond for those issues. And so if you're putting this entity into the hospital, are we doing the reverse? I support the bill, but I'm trying to figure out how do we account for.
I would imagine that the Piedmont Hospital campus hospital police would know more about mental health and would bring that in quicker than some of the police departments around Metro Atlanta. They're probably going to have more expertise and more access to bring mental health resources into law enforcement.
If I may, I think two responses to your question, and I appreciate the question because I'm a big fan of the co-responder units that police are modeling around the state. First, I think the numbers don't necessarily bear out that mental health is the significant contributor to. Certainly, it is a challenging population to manage in healthcare, but we see violence from all measures of patients. But the second thing, and I think as was just mentioned, I think we would bring a stronger sense of compassion and care for the patient first instead of the criminal first, as you see with most law enforcement models. Law enforcement models are really focused on the criminal first as opposed to bringing in the co-responder unit, which is trying to change that model. I think we can do that very well based on our patient-centric model of care.
Okay.
Thank you, Representative. Chair Lee Silcox.
Representative Neal, I really appreciate your comment. And I will say that I know for a fact that, the good news is the people in the hospital are trained to deal with mental health. And you see this a lot at Grady, where patients are appropriately triaged to the mental health area, to the mental health beds. And the good news is I'm sure the officers would be trained to if they had any doubt, to ask the head nurse or someone in charge of that floor to say, was this patient on a certain, types of medications that would indicate that and that sort of thing. So I agree with his point that these people are going to be equipped to deal appropriately with the mental health patients.
Thank you. Yeah, and I would assume to the bill, at least in terms of the text of the bill, it does not purport to change anything about competency or ability to stand trial or any underlying issues that would arise in any kind of criminal prosecution. Representative Kendrick?
Thank you, Mr. Chair. So I wanted to clarify the answer to the question that I asked you out in the hallway. So on lines 38 through 39, well, actually, starting on lines 28 and 29 and 38 and 39, my concern or my hypothetical was someone being totally off, that's a healthcare worker, coming back onto the campus, being attacked, and someone not knowing that they're a healthcare, and all of a sudden having these additional aggravated charges that would be attached on to them. So I'm sorry, what's your name?
Mike Hodges.
Mike. Hey, thanks, Mike, for explaining. So could you clarify what you told me about the prosecuting having to clarify?
Yeah, so the president has set, as we've mentioned with other areas where we have protected workforces or workers, such as police officers, but the burden is on the prosecution in the context of that to prove that that individual knowingly assaulted somebody that was a police officer, in this case was a healthcare worker. And so, we can push for it. You've got an assault either way. There's going to be a
Right.
prosecution either way. The extended penalties, they would have the burden to prove that they knew they were assaulting a healthcare worker.
Thank you.
And I appreciate you bringing up that question. And just to make it clear to the committee, as Representative Kendrick pointed out, we have either on the hospital campus or when they're doing official duties, and then we define the hospital campus as property owned or occupied by the hospital, the sidewalks and streets that are adjacent to it, and then 100 yards. That's been reduced based on feedback we got. So it's been shrunk down to 100 yards. That's kind of the 100-yard dash. If you could outrun the hospital police 100 yards, they've got to go. Well, they're going to turn you over to the Atlanta police. But there are some hospital cafeteria, the hospital gym, hospital gift store. There may be some times that the healthcare workers, they're on campus then, but what if they are across the street rendering aid to somebody who, faints or has a stroke while they're across the street or something like that within 100 yards. So we gave, they're in scrubs a lot of times, they're visible, they're coming and going to the hospital, so we want to give a zone of protection for these employees as they're coming and going from work, whether or not they're actually delivering health care.
So I understand that issue, but the scenario I gave Mike, Mike, what's your last name?
Hodges.
Okay, Mr. Hodges, was somebody not identifiable in scrubs. Somebody, maybe they left something up there and they're just coming up to the hospital to get it. My concern was having somebody attack them. Yes, they would still have the assault, but then the additional charges, not knowing that that's a healthcare worker, because they're not in scrubs, right, in your day off. So thank you for answering
I
that.
think Mr. Hodges may have answered it right. The intent would be judged by the circumstances.
Right.
So if that person knew that that was a hospital employee, but they were not doing their official duties, I guess that's where it would kick in. But really what this bill is aimed at is, providing the campus police, but then also making sure the hospital employees, the doctors, the nurses, the other hospital employees are able to feel safe, and that everybody knows, hands off them, just like teachers and law enforcement and paramedics. Do not attack somebody who's trying to render life-saving medical treatment.
All right, thank you. Any further questions for this witness or the sponsor? All right, thank you, gentlemen. We've got a few more witnesses I want to try to get to. I have 3 more, so I'm going to ask you all to try to be brief. Tim Davis. If you will lean into that mic a little bit, it doesn't pick up very far.
All right. Thank you to the chair and the rest of the committee for allowing us to testify. My name is Tim Davis. I'm the Director of Government Affairs for the Georgia Nurses Association. I wanted to come today and express our support for this legislation. According to the American Nurses Association, over the life of their career, 1 out of every 4 nurses encounters some form of assault while they're doing their job. The governor convened the Healthcare Workforce Commission that's already been mentioned here. We've got a shortage of nurses, and we need to be doing everything that we can to ensure that we keep as many of our nurses at the bedside. We think that this is an important first step towards ensuring that all of our practitioners, while they're at work, can feel safe and protected and doing their job. And so we'd appreciate the favorable consideration of the committee, and I thank you for your time today.
Thank you. Any questions for Mr. Davis? I don't see any. Thank you so much. Julie Wyndham with Atrium Health.
Good afternoon, Mr. Chairman, members of the committee. My name is Julie Wyndham. I represent Atrium Health. We have 5 hospitals in Central Georgia with our main campus there being in Macon, and 4 hospitals in Rome with our in Floyd County with our main hospital there being in Rome. And I certainly don't want to repeat anything you've heard today. I know the hour's late. Y'all understand the need for this bill, but I currently have a police force on my campus in Macon, so I thought I'd just come to you from that perspective, hoping I can answer some questions you may have. We were a hospital authority originally, and that's when we got our police force, and we're grandfathered in when we restructured, and that our workers and our police force appreciate the fact that they are post-trained and certified. They know our hospital. They work closely with our mental health teams. They are trained to recognize when something is simply a crime because someone is acting out versus they're having a mental problem and they need help, and they know to go and get our mental health workers and respond to that. So it does work well for our hospital in Macon, so we think this would be a good thing for the other hospitals in the state to be able to do. Thank you.
Thank you very much. Any questions for Ms. Wyndham? I don't see that you have any. Thank you so much. All right, Ms. Travis, I think you've signed up also. Come on up.
Good afternoon again, members of the committee. Thank you for hearing from me. First, I want to express my sincere appreciation to Representative Reeves for hearing our concerns and working with us over the weekend to hopefully make this bill read a little bit better. Although we still have some opposition to it. It's not a refrain that is uncommon to many of you that have heard me speak before to say we don't think that there should be classes of victims. Because the punishment in Georgia is so broad, aggravated assault and aggravated battery carry a 20-year punishment. We feel like the 20-year punishment is sufficient enough for a judge to look at the circumstances and say, this person deserves a higher punishment than, say, the person that beat up the Starbucks worker. I mean, do we need to categorize every kind of worker to get punishments? So that's just a global objection to this kind of bill that you see before you. The second category of concern falls into the idea that increasing punishment serves as a deterrent. I don't think that it does serve as a deterrent. We haven't had any proof that increasing the punishment serves as a deterrent. What I know you probably can't see this sign, and I'm going to read it out loud to you, but it was a sign I just noticed the other day at the airport in big red letters: no threats, no verbal abuse, no physical violence of any kind. If you threaten, endanger, or harm transportation security officers during screening, TSA will pursue criminal penalties and fines up to $13,910. Weird amount. Thank you for your cooperation. So what I say to you is today, Piedmont Hospital should have a sign up in there everywhere they want to put it up. Be aware that if you hurt a worker here, you're subject to up to 20 years in prison and up to $100,000 fine. I don't think the law needs to change in order to accomplish that goal. To Representative Kendrick's point, I had the same question about the off-duty worker that goes back onto campus for, maybe they have a medical appointment, just happens to be here. I think the fix to that would be on lines 28 and 38 to change the or to and, because while the worker is engaged in official duties and on a hospital campus, because if because if they're engaged in hospital, official duties in somebody's house, I don't think that's a protection. I mean, I do know that some doctors still make house calls. I don't think that's the protection you're looking for. I think it's they're engaging in the duties and they're on the hospital campus. And I didn't realize that potential fix until Representative Kendrick asked that question. So I would have mentioned that to Representative Reeves earlier had I noticed that. But I think that would fix it. That's all I have, Mr. Chairman, if you have any questions for me.
Thank you, Ms. Travis. Any questions for Ms. Travis? I don't see that you have any questions. Thank you. Matt, did you want to respond or sort of give any
Absolutely. Just send some follow-up on the Starbucks analogy. In my area, Starbucks closes before I go to bed, and the hospital's open 24/7, and you have shifts of nurses. CHOA, which I see, coming in early to the Capitol, that hospital, you've got stacking where you've got a shift of nurses leaving there in the wee hours of the morning and others coming in before it, before daylight. And so, hospitals are delivering very stressful high stakes services 24/7, often in early morning or late night situations. There's already an emergency room coverage of this kind of scope. This broadens it to the whole hospital campus. It broadens it out because it's needed. In terms of crimes, deterrence was mentioned. This may not deter. Well, restraint and punishment, those are public policy goals in addition to deterrence. Even if deterrence, if there's an argument against that, you've still somebody who's going to assault a nurse who's there to provide health care, they need to have some restraint and punishment. They don't need to be out there in the position of doing that again anytime soon. The TSA example, that's just not the right model. It's apples and oranges, and they're not out there delivering health care services. And signs, I've passed that feedback in about the signs, and that's certainly something that could be voluntary, but the scope of this bill, signage would not be something that this would either require or prohibit. The location and the scope of this bill, the campus police are not going to be at the doctor's home or the nurse's home, so they're going to be in close proximity to the hospital for these hospital law enforcement to be there to make the charge or the arrest. So I would ask you to keep the "or" because that gives safety and security to these healthcare workers. If we start splitting hairs and creating defenses on the front end, I think that's going to weaken and water down this bill. I think if we give this a try and see if there are any real-world problems that develop, that's the time to fix it rather than watering this down from the beginning. I would ask you to pass it. It's had a lot of input before now, and I think it'll make hospitals safer, and we would ask you to approve it.
Thank you, Representative Reeves. Any further questions for the representative? All right, thank you. I think what I'm going to do, Representative Reeves, due to the fact that we've had a number of changes in discussion, I'm going to have this as just a hearing only tonight, and then we'll try to bring this back for you. I see we have one question from Representative Neal.
I do support the bill, but I do have a question after listening to Travis. Although I support the measure, I do have a question about how far we extend the protected class, or how far we plan to go on extending the protected class. When she mentioned the penalties that we currently have in place. Not saying I'm against the bill, I'm trying to get an understanding of if there is any pause with anybody on the committee, if there's a necessity to adjust, if there's a protected class or not. Because for me, I would rather ensure that the bill moves so we can get the hospital police. If we have to lose something, I'd rather lose that and keep. I would hate to see one part of the bill hold it up.
And Representative Neal, if I could respond to that, first responders, transit workers, law enforcement, seniors, teachers, there's the enhanced penalty for attacks on them. Right now it's 1 year for anybody. It's 3 years or more for some of these other classes. There was one version of this that had 3 years and 5 years. We just put 3 years as the minimum throughout this bill just to keep it uniform. So this takes it from 1 to 3 as a minimum, and it keeps up to 20 for anybody who's assaulted, but definitely these healthcare workers.
Any further questions for the sponsor as our numbers dwindle? Anyone else here to testify to the bill? All right. Well, thank you very much for that presentation. Thank you to all the witnesses, and we'll see if we can't get this back for a vote. Thank you very much. And with that, I believe we've completed all our business. We're adjourned. I know y'all want to keep going. I'm sorry.